One-year-old store supervisor Robert Knockler and his wife, 27-year-old business manager Kimberly Knockler, are suing their next-door neighbor, Terry Adams. The Knocklers say Terry's 9-year-old son, Michael, ordered his dog to attack their 4-year-old son, Houston.
Order. All rise. Your Honor, this is case number 570 in the matter of Knockler versus Adams. Parties have been sworn in. Judge, you may be seated.
Thank you.
Everybody have a seat.
Mrs. Knockler, this is your 4-year-old.
Yes.
And it is your claim that your 4-year-old was bitten by that dog, neighbor's dog, while in the care of the defendant's 9-year-old son.
That's correct.
And you want the defendant to pay you $5,000 for the dog bite, as well as the emotional distress arising from the dog bite. Is that right?
Yes.
The defendant says that your 4-year-old provoked the dog, and she's counterclaiming because she says that you have caused her child some measure of emotional distress, and she's also counterclaiming in the amount of $5,000. So since I assume you weren't present, is that right, when your son was bitten by this dog?
Not at the time of the bite, no.
Who, other than your 4-year-old, witnessed it?
My witness and my daughter and some other people who aren't here today.
Okay, I'll hear from your witness. Would you step up, please? Tell me your name.
Yvette Orozco Contreras.
Are you a neighbor?
Yes, I'm their neighbor.
When did this incident occur?
On the 11th of March,
At what time of the day?
I'd say about 4 o'clock in the afternoon.
And were you outside when this happened?
Yeah, I was in my driveway.
Tell me what you saw.
Well, I saw the kids playing outside. Michael was outside with his dog.
Okay, this is Michael.
Uh-huh.
Michael was outside where with his dog?
In the street in front of my house.
In front of your house?
Uh-huh.
Okay.
And he was just playing around with the dog. And then after a while, he just, I guess, was scaring the kids with the dog.
How was he scaring the kids with the dog?
He was telling the dog to say, sick 'em or get 'em.
Okay. And how many children were around him?
At that time, I'd say about 7.
Was this little boy one of those children?
Yes.
What is his name?
Houston.
So Houston was there too. Was Houston riding his bike, or was
Houston was riding his scooter.
And where was he riding his scooter?
Also in front of my house.
In the street or on the sidewalk?
On the street. We live in a cul-de-sac, so all the kids play right up on the cul-de-sac.
So it was in the street?
Uh-huh.
Where the cars are?
Yes.
Okay. Who was supervising Houston?
I was out there watching them, and other parents across the street were watching their kids too.
And what about Mrs. Knockler? Was she outside watching her son?
No.
At the time the bite happened, I wasn't out there.
You were
However,
not
I
out
was
there.
looking in on them. And my husband was home also.
But neither of you were
We
out
weren't
there?
actually outside, no.
Okay. Then what did you see?
Well, after a while, I saw Michael let go of the dog.
Michael let go of the dog. How did he do that?
He just let go of the leash, and the dog jumped on Houston.
Did you see him actually being bitten by the dog?
I saw the dog do something. I wasn't so close to see the dog bite him, but I did see him do something.
And then what did the dog do?
I didn't pay attention to what the dog did. Houston ran towards me, and I looked at his leg and took him to his parents.
When you saw Michael outside with the dog and you saw him saying, you know, sick him, did you say anything to him at that point?
I really didn't say anything because he was outside for quite a while with his dog. And the dog didn't seem to be dangerous until he started saying those words.
Well, once he started to say those words, did you go over to him and say to him, stop saying that?
No, I didn't.
Well, didn't you think it was a dangerous situation?
I did, but since the dog didn't seem harmful to me, I didn't make a big deal about it.
Okay. How close were the children to the dog when you saw them outside?
They were right next to him.
And did the dog seem friendly? Were they petting the dog?
They were all riding their scooters, their skates, all that, and the dog was just in the midst of them.
Okay. Let's say you're this young man with his dog. How close were the other children?
I'd say to about the end of this table.
So just 2 or 3 feet?
Yeah.
Did this young man tell the children to get away from them if they were riding around on their scooters?
No.
He didn't?
He was playing with them, too.
How was he playing with them?
He was just running around with his dog, too.
So they were all sort of playing together?
Yeah.
Was he the oldest child out there?
No.
Were these two the youngest children out there?
Yes.
How old are your children?
I have a 6-year-old son that was outside playing.
And were you outside at all times watching him?
Yes.
Now, Mr. Knockler, when your neighbor brought your son in, did you examine his leg? I think she said it was his leg.
Yes.
Okay, what did you see?
I saw that it was bleeding, that there was a scratch. My son was crying.
But I want you to tell me about this scratch. Is that a
The bite.
photograph
Yes,
of
we
it?
have a
Yes.
photograph.
I'd
we
like to
took
see it, please.
shortly after you came in. And Your Honor,
Yes.
I know you can't see very well from that picture, and we had cleaned up what blood there was, but as of now, a month later, he does have a scar on his ankle from that.
Well, I'd like to see that. Houston, could you come up here for a second, please? As a matter of fact, come right up here, Houston.
He also had a scratch to his elbow from where the dog jumped on him.
What happened to your foot?
He just scratched me.
The dog scratched you?
Yeah,
Did it hurt?
yeah.
Could you sit up there for a second? Because, you know, my eyes aren't so good anymore. Can you show me your leg? Where the dog scratched you? Oh, I see. Just a little tiny scratch. Doesn't look like a scratch as bad as what happened to your eye. What happened to your eye, Houston?
I just fell on this. Well, we fell on the sidewalk.
Is that what happened to your eye over here?
Yeah.
When was that?
The biggest one happened the day after Houston was attacked by that dog. The little one happened like a month before it happened in front of the property she's renting.
Okay, Houston, why don't you go and sit down? Miss Norkler, how did the large injury happen to your son's face?
He was riding a scooter that he's ridden a lot of times, and the side of the scooter, the padding had come off of the scooter, and that was what went into his face and caused that injury.
Where was he when this happened?
He was right in front of our home.
Where were you?
I was at work.
I was home with Houston that day.
Were you home inside the house when it happened?
We had just got home and we...
Just answer my question.
No, I wasn't.
Where were you?
In the garage, heading into the house.
So you were not outside with your son when he was riding his scooter?
No.
One would think that you folks would have learned a little bit, not to leave a 4-year-old outside unsupervised. So he has 2 injuries in the course of one day. One seems much more severe than the other.
Your Honor, may I say something?
Yes.
Part of the reason why sometimes I'm not outside, sometimes they're not outside is because we know each other very well. And
Were you outside when
kids.
Were you outside when the injury occurred to his eye?
No, I wasn't.
So you weren't outside supervising, is that right?
No, but I'm saying on the day that the dog
I'm
bit.
not talking about the dog. I'm talking about the next day, where the serious injury happened. Not about the day where he got a little scratch on his leg. The day where he got a very, very bad injury. How many stitches did he have there?
8.
Didn't have any stitches on his leg, did he?
No, he did not.
Real cases, real people. Judge Judy. Robert and Kimberly Knockler say their son, 4-year-old Houston, was attacked by their next-door neighbor's dog.
Okay. Did you take him to the emergency room to take a look at that scratch on his leg?
No, we didn't.
So that you were not concerned that the dog required a tetanus shot or anything else?
We knew that he had already had his tetanus shot and he was up to date because of the injury that happened to his eye in front of their property like a month before.
So you're telling me that there was another injury that your son had while he was outside?
He's had a total of 2 injuries that were accidents and 1 injury that was intentional.
What was intentional?
The dog bite.
Dog bite was not intentional. I don't even know if it was a bite. I can't tell if it was a bite or a scratch.
The dog
You can't-
was quarantined.
Just listen to me. You can't tell whether that was a scratch. It looks like a scratch. It looks like a healed scratch. There are no tooth marks in there, nor do I see any in this photograph. So I don't know whether the dog scratched him or bit him. It seems to me if you believe that your dog is bitten, the first thing that you do is you take the child to an emergency room, and the emergency room makes an evaluation as to whether or not the child was bitten or scratched. There is, in fact, a difference. This is not a $5,000 injury, folks.
It's intentional. He told that dog to sick my son. And she has admitted to that.
Listen to me. That's not what she said. She said he was saying to the dog, sick him. There were a whole bunch of children around there. He is also an unsupervised, how old are you?
9.
9-year-old. Just like your son was an unsupervised 4-year-old. I mean, I read it in the paper. The defendant says that her son was, in fact, supervised. She says most of the time this time was different. It's always the times that are different that create a problem.
Not. He's unsupervised a lot. He has harassed a lot of kids.
Let me
in that
explain something to you. I'm looking at his face. He doesn't have the scars on his face that your son has from being outside, unsupervised, and injured twice on his face. I mean, this was an unfortunate incident. He did the wrong thing. There's no question he did the wrong thing. But what I gather here is there has become a vendetta because of that, and that is outrageous. You claim she says bad things about you. You claim that she says bad things about you, and you say that there's an intentional act on her part because her 9-year-old, who was outside playing with a bunch of kids, did a really stupid thing, and your son got scratched.
No, ma'am.
Yeah.
Judge Scheinlin, I would state that it was an intentional act on his part when he was saying sick 'em, sick 'em. She has admitted to that. I don't believe that she wanted this to happen,
So
but
then why
I
you-
believe that
He's
definitely-
9 years old. Your son is 4.
Yes.
Right. You think he's
My
an adult?
baby.
What? That's hers. That's hers.
And I don't have a problem with that.
So then
but
why
she
would you
left
sue her?
him-
Let me ask you a question. So then why would you sue her, your neighbor, over a scratch for $5,000? Why would you do that?
My son came to the door. He was crying. He was bleeding. He told him, sick him. She
I
admits
already
to
heard that. It's not what I'm
That's
asking you.
Because of the intentional nature, because of the fact that it is very upsetting that somebody would tell a dog to sick a child.
You're absolutely right. If an adult did it and the dog did it, you put him in jail. 9-year-old does it, they're not so smart.
She knows that he has a habit of harassing other children in the neighborhood.
Well, madam, if you know that that's true, then when your witness saw him outside with the dog and was standing outside supervising all these children, she should have said something like, I suggest you bring Houston and your daughter inside because he's outside with that dog and not doing the right thing. She wasn't concerned. She just told me they all seem to be playing. Isn't that right?
They did all seem to be playing, but he was taking advantage of that.
Then
Houston
why
was
didn't you
scared of
stop
the
him?
dog.
Then why didn't you do anything? What kind of
He doesn't
supervision is
listen.
that?
He does not listen. He's attempted to take
Then
my
you
daughter
bring-
to the pool where she
Madam,
cannot swim.
then you bring your children inside and you speak to the mother later.
The mother does not listen either. She knows her
Listen.
kid does this.
I'm going to get to the counterclaim for a second because you ain't hearing me. Now, you have a counterclaim that I believe is a little bit of a nonsense, but I'm going to give you an opportunity to tell me about it. Go ahead.
Okay, Michael has not, first of all, played outside since the incident, only in our backyard. And on Sunday, we were getting ready to leave. He said, can I go out front? The kids are out there. I said, sure, just for a few minutes. I'm on my way out. Michael walked out front. Kimberly was in her driveway. There was a bunch of kids out front, and Kimberly told my son, watch it, kids. Here comes the trashy kid. My son came in the house very upset. I walked back out with him. I said, let's go. We need to go. And I said, Kimberly, I don't understand why you would call a child a name, being a teacher. And then I said, I don't have time to get into it right now. My contractor's waiting for me. I have to go. And she said, wait, let's get into it right now. And she went off. She went off yelling, saying, I'm neglecting my kid, called me a and she just kept going off. And I said, this isn't any way a teacher should act. You're supposed to set an example for our kids. If you want to talk, we don't yell and scream. She said, I better get into my car before she beats me. And I left.
Nasty neighboring. If it's true, it's nasty neighboring. It's not worth $5,000, and neither is the dog scratch.
Right. I do have some stuff I'd like to submit to the court, please.
Go ahead.
One regarding the police report, which is actually contradicting what Yvette's testimony is and what she told the police.
She's being dishonest. That is a reinvention of history. I did not state those things to her. I did not call her child a name. That did not happen at all.
What did you say?
All I told my children to be careful.
Really?
I didn't say trashy.
Just a second.
And she called the cops to my home, what, 5 or 6 hours later?
Can I read this, please?
Please.
Quiet.
Yes, I'm sorry.
Yeah. Well, let me tell you what the police said, Ms. Contreras, that you told them, and these quoted in the police report. I asked her if she heard Michael sick the dog on Houston, and she said no, he didn't intend for this to happen. I asked her what she meant, and she said Michael did not intend for this to happen, he was just playing around. I asked her if she was positive that this was an unintended event, and she said she was positive. Did you tell that to the police?
I did. What I meant is that I don't think Michael did it on purpose. I don't think he really...
Well, she says it's intentional, so that you don't agree with her.
I think that
No, just
he
a
was
second.
trying to scare...
So that you don't agree with her that it was an intentional act.
Well, from the looks of it, it looked like he was just trying to scare them, and unfortunately the dog did something
Well,
to
you
him.
told the police that he was just playing around.
Well, yeah, he was playing around.
Okay.
And he,
Playing around in a scratch don't add up to anything.
Your Honor, our dog Trixie plays tag with the kids frequently, the one he is playing outside, which means when Michael runs with him, he jumps up and tags them, he licks them. He was playing tag with the other kids that day as well.
Whatever.
And
if you have,
the count...
just listen to me.
Okay.
If you have a 9-year-old and a dog. And you acknowledged to me in your answer, madam, that your son is told not to take the dog outside if you're not home. Is that right?
That is right.
So he disobeyed you?
Yes, he did.
And I assume that he was punished for disobeying you?
He was consequenced.
Whatever that means. I don't know what that means. Does that mean like a timeout?
No, that means he's been unable to play outside unsupervised at all.
But that's what happens. You know, I don't think that this was an intentional act, and certainly if the child had been bitten and injured, the result here would have been different. Put your paper down. The result here would have been very different. I see no evidence that the child was bitten. I see evidence that the child had a scratch as a result of this unfortunate horseplay, which was really your fault. Do you understand that? You understand that? Okay. If you hadn't disobeyed your mother and either stayed in the house or left the dog in the house, all of this wouldn't have happened, right? So you have to learn that you have to do the right thing, not the wrong thing. As far as your counterclaim is what? Okay. What? So far you're not losing. What are you complaining about?
Well, I have more evidence on the counterclaim. She's slandered us to CPS. She's slandered us to the police department.
Let me see the CPS report.
This is actually the report from our therapist, and this is the CPS worker. She said
Did you
that
call
the
Child
report...
Protective Services about her?
It's in my answer. The date that this happened, they came to the door, my neighbor and the other person, and they said Houston was outside and that Michael had the dog bite Houston. I walked outside and I said to Michael immediately, Michael, go get your sister. She's not home. Michael, go get your mom. She's not home. Michael, are you alone? Yes. I called the police.
Why did you call the police? I don't
believe-
understand why you called the police. Your son had a scratch on his leg. Period.
The reason I called
Wait
the
until your
police-
neighbor gets home and discuss it with her.
That's right.
I don't know when my neighbor's gonna be home.
Oh, madam, your case is dismissed. Listen to me. Totally, completely dismissed. I mean, I think your conduct that day as a neighbor was outrageous. And I would be more concerned about you two people supervising this child, because this child looks as if he's been through a war zone in your custody, all over his face, when he's been totally unsupervised by you. Maybe you just rely on Mrs. Contreras to supervise your children when they're outside. But he's 4 years old. And 4-year-old has had an accident on one day and a terrible accident on the next day and a month before an accident outside, and you're nowhere to be found. So I would be more concerned about you supervising your own child. Your son was scratched by the defendant's dog. It was an unfortunate circumstance that did not require you picking up the phone as a neighbor and calling the police. It required you waiting, cooling down a little bit, and when she came home, perhaps go over to her house, give her a buzz and say, listen, something bad happened today. I want to tell you about it because my son got a scratch on his leg when your dog jumped up on him. Your son was not doing the right thing. Nobody was supervising him. And I want to tell you, if it happens again, I'm going to contact the authorities. If you wanted to do that, I would have no objection. But to call the police, you're outrageous. But I'm not giving any money. That's all.
Yeah, this is case number 400 on the calendar in the matter of Cleary versus Tibbs. Parties have been sworn in. Judge, you may be seated. I'm going to have seats. You're welcome.
Mr. Cleary, it is your claim that the defendant threw a trash can at your car one evening, causing damage to your car. Mr. Tibbs says that he had nothing to do with throwing this trash can at your car. When did it happen? Where were you? And what were you doing?
It was November 9th, and it was after our school dance. And me and my friend and 3 other people were at the park with our friends, and Stephen Tibbs showed up, and we were just all hanging out there, you know, just looking for something else to do. But it started getting late. It was around 12:40, and I had to be home at 1. So I was like, I'm leaving now. And the girls, the ones that I gave a ride there with, they knew I was the only one there not drinking, and so they wanted to...
That's a lie, Your Honor.
They knew I wasn't drinking, so they wanted a ride home with me because they wanted to go to the party because Tibbs asked them to go to a party. And when they said no, they were going to get a ride home with me.
That's a lie.
What word didn't you understand? I said, be quiet. Go ahead.
Tibbs became very angry and to a point of violent. When the girls started getting in the car, he was pushing them, and one of the girls' leg was still hanging out, and he slammed the door on her leg, or he tried to, and I mean, it bounced off her leg. After we got in the car, we could see him. He had the trash can picked up, and people were yelling, Tibbs, no, Tibbs, no.
Did you see him with the trash can in his hand, not the girls?
I saw him with the trash can in his hand like this. He had the trash can up around his head level. And I was parked. I had to back up and go like that, and he was on this side of me. When I backed up, he hit my car with the trash can.
Okay. And may I see the estimates of the damage and any photographs that you have? So the trash can didn't hit the top of the car, it hit the side of the car.
Yeah, the rear right fender.
All right, Mr. Tibbs, now I'll hear your version of the event, sir.
Okay.
Now it's time to speak.
All right. I have a little bit of different story. First of all, I didn't throw the trash can at his car.
Let's start from the beginning. You're out in the field with the park.
Yeah, I'm at the park talking to girls, and I'm with my witness, Frank. I see Mike drive in. He drives in kind of crazy. His tires were screeching. He came from the dance. When he got out of his car, he was drinking beer. For the half hour we were there, I seen him drink 3 beers personally. He stumbled back into his car. He backed out, peeled out, and I watched him fishtail into the trash can. The damage was on the bottom right-hand side. I watched him hit the trash can.
So you did not throw the trash can at his car?
No, ma'am.
Okay, do you have any witnesses here, sir?
Right here.
Step up. Tell me your name.
Sean.
Sean what?
Blevins.
Tell me what you saw.
Well, when we got there...
Look at me.
Sorry. When we got there, we were talking with the girls.
I want your eyes to stay fixed on mine.
Yes, ma'am.
Do you understand?
Yes, ma'am.
Good.
Steven came after...
Your eyes are moving around.
Came like 5 to 10 minutes later, and he was drinking. Had friends with him, and then we were going to leave, and he got mad at the girls because they didn't want to go to the party. So he started to become violent with the girls and started like pushing them around. Okay, fine, then you, and stuff like that. And then we got in the car because Mike had to be home later on that night because he had something to do the next day. And we started backing up, and I heard people saying, "Tibbs, no, Tibbs, no." And I looked out the back of the car because I was in the back seat, and he had a green garbage can in front of him, and like the driveway comes in right here, and there's like a little island type thing where you could park next to it, and the trash can was right here, and Mike was parked over here, and Tibbs and a whole bunch of other people were standing over here. And then we backed up, and we went to take off because we were giving the girls a ride home, and he threw the garbage can at the car.
You saw him throw the garbage can at the car?
Yes, Your Honor.
Did you see it hit the car? I want you to listen to me very carefully, because I've looked at the damage to the car. And I'm not saying he's not responsible for the damage. My question is, did you see the garbage can at that time hit the car as he threw it?
Yes, Your Honor.
Or did you see it hit the ground and then bounce up at the car?
No, it hit the car. He was like this, and he threw it at the car, and like the corner of the garbage can, it hit the fender, and it dented it, and then it fell down, and all the garbage and everything came out of it.
Now I'll hear your witness. Your name, sir?
Frank Ambrose.
Where were you standing?
I was standing by my truck. I was the one driving.
Who were you driving?
Steven, just me and him by ourselves. We went there to meet up with girls. It's right by the school parking lots.
Okay.
The park and everything. We meet up there a lot. We went there. When we got there, he was with a bunch of girls. I don't remember seeing his witness. This is the first time I've really seen his witness out of school. We got there, he was drinking, girls were drinking. He had really no part in what we were doing there. We weren't paying attention to him. When he left, he screeched out, and girls were screaming. They had bottles, probably showing off, and he was doing donuts, or peeling out, making and then you hear a bunch of screeching, you hear a loud crash, and you hear silence after that, and everyone look over there, and you see his car stopped with the brake lights, and there was a trash can in the middle with the trash everywhere. And he didn't do anything, stop or confront any of us, look back or anything. He stopped, and we were going to wait for him to get out the car. It was about 15 seconds, but it felt long, and he just drove away. And we didn't hear of anything, Steven Tibbs' name into it, until that happened about a Friday, I would say, because it was dance, until I think Monday or Tuesday at school, him trying to blame Steven Tibbs. And Steven doesn't even go to bar. I think that's why.
A note for yourself, Your Honor. Mike contacted my father at my house and told him, he said that I threw a trash can at his car. My dad said, if I committed a crime, then file a police report. A police report was never filed in this case.
Real cases, real people. Judge Judy. Michael Cleary says former schoolmate Steve Tibbs threw a trash can at his car.
Mr. Cleary, I have 2 witnesses on each side, and all of you look as if you're telling me the complete truth, right?
Right.
So all I can do is look at the photographs that you provided and try to find something that's consistent with either story. Now, both you and your witness say that he was standing not far from your car, correct?
Right.
he picked up the trash can over his head, and he's a tall young man, and he threw it at your car. Well, if he picked up the trash can and threw it at your car, you would have damage to the top part of your car. Or even if it landed on the side of your car, most of the damage would be on the top part. What you've shown me here is mostly damage that starts at the underside of the car. And that would be quite a trick. If the trash can was over his head and in a downward motion he threw the trash can and it landed on your car, the damage here is inconsistent with that. It's more consistent with either he may have thrown the trash can and it may have collided at the same time he threw it with your car and sort of bounced up and hit the top of the, the top of where the wheel is. That's why I asked your witness whether the trash can hit the floor first and then the car. He said, no, it hit the car first, right?
Yes, Your Honor.
I cannot be satisfied based upon the statements of the witnesses and these photographs that you've established your case, Mr. Cleary. Anything else you want to tell me?
Yes. If you look, there's damage to the tire because it goes like this, right? And it was bent down. It hit the base of it, where it protects the wheel, and that's why it's bent down like that.
It hit the base of the wheel, but that is also consistent, Mr. Cleary, with the defendant's statement that you would do in figure eights around the parking lot and hit the trash can. It's also consistent with that.
If I was spinning donuts, my whole car would hit the trash can, and it would have been a bigger dent.
I don't know that at all, sir. I know that there's a lot of damage right on the lip.
Because that's where the trash can hit the lip.
I know, you were inside. I can't make a judgment, certainly, sir, even by a preponderance of the evidence that he's responsible for this. Where are all the girls who were there? All the girls who were shouting, no Tibbs, no. Where are all the girls?
Their parents didn't allow them to come.
This may be one of those cases that is never going to be solved, but based upon the evidence that I've heard today, I cannot conclude by a preponderance of the evidence that Mr. Tibbs is responsible for this. Mr. Tibbs, only you know whether or not you did it, right?
That's correct, I didn't.
You didn't. Bye.
Apologize, excuse, you may step out.
He was mad because the girls weren't going to his party like he wanted them to.
He doesn't like me at all.
He was drinking a little bit, and he just had a bad attitude about it.
He hit the trash can, sliding into it.
My car don't have enough power to showboat. I got a 4-cylinder piece of crap car.
He wants someone else to pay for his mistakes. That's what it comes down to.
And now the next case.
All parties in the matter of Long versus Merovitz, step forward, please.
31-year-old business owner Tom Long is suing his ex-boyfriend, 21-year-old salesman Dan Merovitz, for unpaid credit card charges and a trip to Europe.
According to your complaint, you and the defendant met on the internet sometime last year, is that right?
Yes.
And began a relationship that lasted for how long?
About 8 months.
Did you live together during that period?
Most of it, yes.
It is your claim that during the time that you lived together, you made certain loans to the defendant. Loans that were made by virtue of your credit card?
Yes.
Some cellular phone expenses, and the cost of his share of a trip to Europe that you took together, that you claim that he promised to pay you for, but never did.
Correct.
The defendant says that all of these expenses were gifts. While he acknowledges the expenses, that he made certain charges, he said that they were all gifts from you made during the course of a relationship. So that's where we're at. When did you and the defendant begin living together?
May of last year.
When did you give him access to your credit card?
Maybe 2 months after that. He was getting a promotion and he needed it to keep his job.
What do you mean he needed it to keep his job?
With his promotion, he had more responsibility. He had to entertain, he had to travel, and without that, he probably wouldn't have been able to keep his job.
Did you get him his own credit card, or did you give him yours?
It was basically a partner card off of my account with his name.
So far, is it correct that you had a partner card of the plaintiffs starting in about July of 2000?
Yeah.
Now, when you got the bill, let's say in September, and you were still together in September of 2000, who paid his portion of the bill?
As Dan would get company funds back to him on his expense checks, he would either write a check out to me or just reimburse me in one way or another with money.
Is that correct?
For the most part, yeah.
What about October do the same thing?
As he would be paid by his company, he would pay me back.
So far, is that correct, sir?
Voluntarily, yeah.
I love it. You would pay him back.
Right.
Now, you separated, according to this, sometime in November?
That sounds correct, yes.
At the time you separated, what was the balance on his card?
At that time, it was probably around...
Don't give me a probably around. Courts don't deal with probably around. Where's the paperwork? Don't give me a whole lot of paperwork to look through. Make it easy for me.
It's a quarterly expense report. It has everything.
Just make a little check mark with regard to where his expenses were on his card.
Every single one. It's just his side of it. It's not mine or not included.
I thought I was going to get him to do this for me. Did you do a lot of traveling for your business, sir? Stayed at the Radisson in Sarasota. Good deal? Is that right?
Yep.
Okay. There is no question in my mind, based upon my examination of the defendant, that he treated this money as a loan. Despite the fact that he claims in his answer that it was a gift, he treated it as a loan because, according to him, he made payments. He made payments in September. He made payments in October. Isn't that what you just said to me? Well, even though you said voluntarily.
Right. But none of it was an agreement throughout the month.
Listen to me. Baloney. If you made payments, that is indicia that you treated your credit card as a second holder for your company expenses. Many of these, the most substantial of these, are company expenses. You treated them as a loan because you paid him back. There came a time when you stopped paying on the credit card. On what day did you stop paying on the credit card, sir?
I think when I left, when we split.
Why?
Tom gave these things to me. I voluntarily gave him the checks on a month-to-month basis.
All right, let me ask you this question, Mr. Meyerowitz.
Yes, ma'am.
Do you honestly believe that Mr. Long, had you not paid him back as you got these checks for reimbursement from your company, would have continued to allow you to use the credit card?
I don't know.
I don't know.
Yeah. There were many
Well, why
threats
would you
throughout the whole
think,
time.
Mr. Meyerowitz, not only were you getting substantial monies back from your company, you expect him to pay the bill and you get reimbursed and you put the money in your pocket so that you get extra money. Is that what you're telling me? And that the money that he advanced you on his credit card, sort of like additional salary to you.
Right.
Is that what you're claiming? Is that what you're claiming? I just want to know your position. That he was giving you this money and he was saying to you, you can keep the checks that you get from the company to cover your cell phone and your hotels and your meals and your client entertaining. You keep that because I want you to have that extra money. That's what your position is.
Right. I'm not.
Oh, I'm getting too old for this. Wrong! All right, now let's deal with the trip to Europe. Let me hear about the trip to Europe.
Well, I had a lot of Sky Miles points, and I had told Dan if he paid $500 worth of the entire trip, I would pay for everything else. And he paid about $100.
When did he pay the $100 towards the trip?
Probably on his own credit card when he was paying for a dinner or something.
You mean on your credit card?
No, actually on his own this time.
Oh, it's hard to use your own when you have somebody else's.
I didn't even have my own.
Whatever. But what expenses did you actually incur for him in Europe? You used your points to get there.
I have that right here for you.
Okay. These aren't $500 worth of expenses.
There was also cash involved.
I mean, we're talking about a couple of meals, $31, $7.47, $9.99.
Well, it doesn't cost $500 to fly to Europe. It costs considerably more.
You used your points.
But I had to pay for some of it also.
Where is that?
I only had so many points.
Where? Show me where.
I don't have that right now.
Well, now is the time to have it. We don't have it later. Later is no good. We can't do approximates, okay? So I am deducting that from your total claim, leaving a balance of $2,439.
Actually, I have checks which are on a canceled account, and I also have...
So what does that have to do with anything? I am awarding you everything except the travel expenses. So what difference does it make if you've got canceled checks? I do not believe, Mr. Meyerowitz,
because it actually
that this
cost me $2,800 and whatever the 330, or it cost me that amount of money.
I've just looked at this. This doesn't come to $400. And even if it did come to $400, the expenses for going out to eat, et cetera, have to be cut in half because you ate too. I assume you didn't
Correct.
say you go eat and I'm going to go eat. Don't
That
push
was
your luck,
really a
Mr.
cheap
Long.
trip to Europe.
He is responsible for all of his expenses that he made on the credit card. I find that they were not gifts. I find that his payments were not voluntary. I find that he agreed to pay you for those, and that he did in fact pay you for some until the relationship terminated. So I am awarding you that part of your claim, which is $2,439. I am not awarding you the money for the trip. Judgment for the plaintiff. That's all.
This is case number 377 on the calendar, the matter of Nichols versus Kirk. Parties have been sworn in. Judge, you may be seated. Sir, have a seat, please.
Mr. Nichols, it is your claim that the defendant, who was your roommate for about 10 months, owes you for 10 months' rent and utility bills. Ms. Kirk says that she had a unique arrangement with you, which was that just her being there was enough and she owes you nothing. Is that right?
No.
I assume you signed the lease?
Not in the presence of anyone that should have been there at the time, Your Honor.
Did you sign a lease?
Yes, Your
All
Honor,
right.
I did.
How did you know each other when you signed the lease?
We were friends.
Just friends?
Yes.
All right. How did you first discuss with the defendant moving in together?
Well, she came to me and was, looking for a place, and she wanted to be closer to work, and we went looking out for an apartment together.
Okay, and you found an apartment.
Yes.
Did you both sign the lease on the apartment?
Yes, ma'am, and I have documentation of that.
Can I see it, please? Now, I see in this lease agreement that you've signed it, sir.
Yes.
And that the defendant signed it, but then in parentheses is written month to month only. That means that you were a month to month tenant only?
We came into a year's lease.
Yes, Your Honor.
And the way the lease was set up, it was basically set up for month to month, but written for a year.
No. What this looks like is that you've signed the lease. She signed, but under her name is month to month only.
Okay, it was agreed that it was a year lease, but written month to month.
Clearly, you signed the lease, right?
In the apartment with no one there. I did not one time go to the rental office.
You don't have to see anybody to sign a lease.
Okay, yes, Your Honor.
So you signed it?
Yes, ma'am, Your
Fine.
Honor. I did, on my own time.
I don't care if you
It was signed.
signed it upside down on Mars.
Yes.
You signed the lease.
Yes, Your Honor.
And what was the arrangement, according to you, with regard to payment of the rent?
The rent was supposed to be, as well as a security deposit, split 50-50 straight down the middle.
Did Miss Kirk give you the security deposit?
No, Your Honor, she did not.
And you moved in anyway?
Yes.
And according to you, for the entire time she lived there, she paid no rent?
Correct.
So what'd you let her stay there for?
She did a few things around the apartment for me.
Like what?
Cooking, cleaning, and just being a friend.
So you were satisfied with that arrangement?
It was understood that she would eventually be paying me, but,
Well, how was that understanding reached, Mr. Nichols?
Your Honor, we had a verbal as well as a written agreement.
No, there's a written agreement. That's with the landlord, but you were paying the rent, right?
I got stuck with the rent, yes.
Right. Well, why didn't you tell her to leave after a few months if she wasn't paying the rent?
Well, I knew it would be hard to find another roommate for one.
Well, you didn't try. And it couldn't have been any worse, Mr. Nichols. Could not have been worse. You had somebody living with you who wasn't paying rent. Couldn't be any worse living alone.
Well, that may be true.
So what happened, sir, in October?
In October, we had a falling out, and she left.
Tell me about the falling out, because maybe then I understand why this lawsuit.
Well, it was just a disagreement, and there was some alcohol that was involved, and I don't remember 100% what it was all about, but we did have a disagreement, and she left.
When you say you don't remember, is that because you were consuming the alcohol?
We both were.
Both of you?
Yes.
Now, it was after she left that you decided to sue her for the rent?
Yes, that's correct.
Okay, Ms. Kirk, now I'll hear you.
I met Mr. Nichols.
Just make sure whatever you tell me is true.
Yes.
You got it? I don't want to hear I didn't sign the lease in the presence of 4 eyewitnesses. I want to hear only the truth.
Yes. Good. I met Mr. Nichols at a time I was very vulnerable because I was still in the process of drinking voluntarily. Mr. Nichols offered me a place to stay without signing any agreement financial-wise. He never wanted any money. I tried to offer him money, and February 5th of 2001, I did give him a money order for $300.
So you gave him a money order for...
I have proof.
$300. Now, what was that for?
I felt bad. I felt guilty because he never wanted any money. I tried to give him money. And so, in a way, maybe to make me feel better, that's what he wanted, was money. So I wanted to show him that, yes, I could pay my own way.
Just a minute. When you said you gave him the $300 because you said he wanted money.
I felt he wanted money, but he never...
What made you think that he wanted money?
He had said something to the fact that he was not getting enough hours at his work, and I was trying to help and give him this money order on my own.
Fine. Any other money exchanged after February?
No, Your Honor.
Did Mr. Nichols ever bring up the issue of rent to you
No,
after
Your
February?
Honor. No, Your Honor.
Okay, so what happened in October that caused you to leave?
October 20th, I believe it was a Saturday evening. We were both drinking. I drink a beer. Yes, it is alcohol. But up until that time, Mr. Nichols had been consuming hard liquor, is what I call Jack Daniel's Wild Turkey. I was sitting at the dining room table, happened to get up to proceed to the kitchen area. Mr. Nichols was standing right here and grabbed me by both of my arms, tried to pull me forward. This is only one occasion, but this is the main occasion incident that should be brought out. He has before, in the past, tried to grab me and make me kiss him, make me give him a hug, make me tell him that I would love him or I love him, that I would stay with him. And it was made clear from the beginning that it was only a platonic relationship.
Okay. Now, on the 20th of October, he made an advance towards you.
Physically, yes.
And you left.
He made physically advances towards me, tried to push me down on the floor. Mentally, I believed where I knew that was going to go to. I got up, grabbed the phone, called 911. The phone did go through. Evidently, whoever was on the other end heard what was going on. I got up, well, still had the phone. Mr. Nichols grabbed the phone, evidently pushed off. I ran into my room, locked the door. The next thing I knew, the police were at the door. Knocking, I ran, went out of my room, ran to open the door, there's police. And explained to both of them...
were you taken into custody at that time?
No.
You were not?
No.
Okay. Were you taken into custody subsequent to the 20th of October?
No.
No. Okay. But you left shortly thereafter?
2 days, 2 mornings after.
Judge Judy will continue. Real cases, real people. Judge Judy. Daryl Nichols says ex-roommate Joyce Kirk owes for 10 months of rent. Joyce says after Daryl got drunk and made a physical advance, she moved out.
Mr. Nichols, the issue is very clear in this case, and it's a single issue. Whether or not I believe that in a strictly business relationship, because you were not boyfriend and girlfriend, you were living together as roommates, you would permit your, in effect, business partner to take advantage of you for a period of 10 months without paying any money on a promise that she would somehow pay in the future, and this despite the fact that Ms. Kirk was fully employed during the 10 months that you lived together.
Your Honor, may I interrupt for just a second, please?
Sure.
She would be going in and out of her job about every other month. She was not employed the whole time.
Whether she was employed for the whole time or not, the months that she was working, there would have been no reasonable excuse for her not to contribute her half of the rent, nor for you to permit her not to contribute her half of the rent. Now, there might be some credibility to your story, Mr. Nichols, if, in fact, she was not employed during that 10-month period. And out of the goodness of your heart, you said, look, I know you're looking to get a job, something's going to come up, I will carry you for these months until you get something. But that's not the case. Her circumstances weren't going to change. Her circumstances were she was employed, she had a job, you had a roommate, and you should have collected the rent every single month. You didn't do it. So there's something to be said for Ms. Kirk's position that you really weren't looking for rent. Even Mr. Nichols, you said to me at the beginning of this case, she was cooking, she was cleaning, she was good company, and that's why I let her stay without paying me rent. The case is dismissed.
Parties are excused. You may step out.
There's something in here about him wanting to kill me.
I have no comment.
Got to stop thinking of me and her as a couple.
I have no comment.
Now we barely tolerate each other.
I have no comment.
Otherwise may end up killing her.
I have no comment.
I feel somewhat sorry for Mr. Nichols.
I have no comment.
I was proven right that from the beginning he was looking for more than just rent or a roommate.
I have no comment.
And now the next case.
All parties in the matter of Carson versus Greenberg. Step forward, please.
Holistic therapist Annabeth Carson is suing her ex-boyfriend, mortgage broker David Greenberg, for the over-mileage fee on a car lease. David says the charges are due to Annabeth's negligence.
Ms. Carson, the facts in this case are not very difficult, and I believe that they initially are conceded by both parties. You and Mr. Greenberg were in a relationship back in 1997, 1998. And in 1998, you leased a car for him. You leased it in your name because he had been going through a divorce or something and his credit was not good. So that the car was leased in your name, but with the understanding that Mr. Greenberg would be fully responsible for the car. Is that correct?
Yes, it is.
And sometime in 1998, the two of you separated. And the car remained in Mr. Greenberg's possession. Mr. Greenberg made all the monthly payments on the car, took care of the insurance on the car. You had very little, if any, contact with each other, and then you were notified sometime in 2000 or 2001 that you owed the leasing company over $5,000 for excess mileage that Mr. Greenberg had accrued on the car from the time of the initiation of the lease. You want Mr. Greenberg to pay that money, right?
Yes.
When was your first communication with the bank?
I started communicating with them in December of 2000. I was in touch with them throughout January.
Yes.
The car was supposed to be returned on January 5th.
Right.
It was not returned January 5th, and it was finally returned on the 26th of January. So during the entire month of January, I was on the phone with some of the bank officers trying to figure out how to get the car to be returned.
How did you finally figure out a way to get the car returned?
He just returned it finally on the 26th of January.
Your Honor?
Yes.
If she was in contact with the bank since December, they would have known. The bank contacted me on January 7th and asked what my intent was, and I said that it was my understanding could either continue leasing it and or purchase the vehicle. At that time, they said that they could only sell the vehicle to the person who was originally on the lease. I told them I had no way of contacting Annabeth. They said that they did. They would contact her and to get that permission. So I would never have had to return the vehicle on the 26th. I could have gone through with my plans of purchasing the vehicle.
Let me see your bill.
And I also never received any calls from the bank at any time.
Why should she be responsible for your bill, sir?
No.
Why should she be responsible for your bill? She didn't drive the car.
It wasn't my bill.
It was your bill.
How could it have been my bill? If I purchased the vehicle, there would not have been a bill.
It was your bill. It wasn't her bill. She didn't drive the excess miles.
If the vehicle had been purchased...
Listen to me carefully. It was your bill. She did not use the excess miles, sir.
Your Honor, she knew the type of job I had and that I drove excessive miles, and it was always the intent, my intent and our agreement for me to purchase the vehicle.
Then you should have made those arrangements, sir. You should have started, you should have gotten an investigator. Listen to me carefully. You use the internet?
Somewhat.
If you use the internet, and if you can't get in touch with her, you put her name up on the internet, they'll tell you in what state she's located. You find her and write her a letter. And you say, please, I don't want you to be stuck with excess miles. I want to purchase this car, okay? And this is the only way I have to get in touch with you. If I'm not permitted to purchase the car, then somebody is going to have to pay excess miles. It's not going to be me, because that was not our agreement. I want to buy the car. Now, do you think that she wouldn't have let you buy the car, sir, if it meant that she wasn't going to be hit with a bill for all this money?
I had instructions from Annabeth not to contact her.
Mr. Greenberg, you're a faker, sir.
This...
You're a faker, sir.
Absolutely not.
You're a faker, sir. I'm not telling you not to contact her, not to go see her, not to send her flowers, not to send her candy, but to send her a registered letter saying, listen, if I can't purchase this car, it's possible that somebody is going to be responsible, and it probably will be you for the excess miles. So please, let's make arrangements. If I can't purchase this car, and so far I'm not sure that that's not true, if I can't purchase this car, why don't we make arrangements? You purchase the car, I will send you a certified check for the amount of the car, case closed. And then the car will be mine. That's an easy. You don't have to be a genius, and you're not a stupid man. Shifty, but not stupid. Did you settle with the bank?
No, I have not settled with the bank.
Your Honor?
He wanted me to settle with the bank, and I wasn't willing to settle with the bank until it was clear to me that he was going to take responsibility for paying for it.
This is from, looks like a collection agency. It says, our client will accept 75% of the total balance due to settle this obligation.
I only gave you that form because that shows what I owe. That's just the one that I had.
I'm asking you what they're prepared to accept to settle this bill.
Well, apparently, according to that, they're prepared to accept that. At this point, they might be prepared to accept something different. I don't know. I haven't discussed that with them.
Well, let's go and find out.
And Your Honor?
What?
Wouldn't it have just been as easy for Annabeth, having known when the lease was up, to have made that call to the bank on January 5th?
She didn't use the car. You did. It was your responsibility.
She was on the lease.
Your responsibility. She was on the lease as a favor to you.
She was on the lease.
She was on the lease as a favor to you. If she wanted to, sir, she could have bought out of this lease a year after she had the lease, may have taken a loss when you separated, and said, I'm not leaving you with this car that's in my name. She could have done that too.
I offered to give it to her also at that time. But if I signed a lease for someone and I knew it was up, I would make the final arrangements.
Would you?
Because I would have been
because
responsible
you're really
for the
How old
vehicle.
are you?
49.
Sir, you were 49, so you were 44 or 45 when somebody else had to assume the responsibility for leasing a car for you because you were so irresponsible in your personal or financial life that you had no credit to buy or lease a car. So don't suggest to me that you are so responsible that you would have taken over the obligation of doing what you were supposed to do, because at age 45 you weren't able to do that when you needed a car to get to work. Now, let's find out from the bank what they're prepared to settle for. This is Judge Judy Scheindler, and I'm calling you from Los Angeles. I'm in the process of trying a case involving the people that are involved in this lease. I have a letter here that you sent dated the 5th of October of '01 to Miss Carson, who had leased the car for Mr. Greenberg. So what I want to know is, at this point, what is the bank prepared to settle for to close out this account? $41,25.79. Now, my next question to you is, if this matter is settled, okay, for $41,25.75, and you receive a check for that, is there any negative impact on her credit? Okay, so you get a paid letter. Very good. Thank you very much, sir. Thank you, you too. All right. I've had an opportunity to speak to this FMA Alliance Limited, who were really a collection agency. The gentleman was very cooperative. The amount due as of today is not $55,3807. They're prepared to resolve this matter for $41,25.75 with a check made payable directly to them from, of course, the defendant. So judgment for the plaintiff in that amount, $4,125.75, with a check being made payable directly to the company. Thank you. That's all.
It's case number 554 on the calendar in the matter of Frawley versus Shapiro. Parties have been sworn in, Judge. You may be seated.
Mr. and Mrs. Frawley, you and Mrs. Shapiro are next-door neighbors, I assume. Is that right?
That's correct.
According to your complaint, Mr. and Mrs. Frawley, the defendant's gardener caused some damage to a cover of a trailer that was on your property.
Correct.
And you want the defendant to pay for the damage to that cover. Additionally, you say that you were forced to put up 2 separate fences on your property, separating your property from the defendant's property, and you want her to pay for half the cost of those fences. That's correct. What your case is about. The defendant has a cross-complaint that you maliciously cut down a branch of a tree that was very precious to her, and she says that you have been harassing her, so she has a counterclaim. So this sounds like a very untenable situation for people to be in. neighbors who don't get along. So let's hear about the problem with this tarp cover that was covering your trailer.
Well, on December 18th of last year, my wife and I returned home from work and noticed our travel trailer cover had sustained damage. We noticed or examined actually the height and the pattern of the damage and concluded that it was caused by the exhaust of a gardener's leaf blower.
It had burned like a 4-foot-long hole across the cover, and you could tell that it was a burn mark.
Let me see, you have pictures of it, I assume?
Yes, sure. That's it.
Okay, so you came home and you found these burn holes. What did you do?
My husband had seen four gardeners on our driveway before when he happened to be home from work a day when they had come, and he had asked them not to stand on our property because their backpack thing actually put some dents in our trailer. But when he mentioned it to them, they just kind of acted like there was a language barrier, like they maybe didn't understand.
So you had seen them standing on your property, blowing the leaves on the defendant's property through her property.
Well, I only observed them the one time, and there was an individual standing on her property and an individual standing on my driveway. And I asked the one standing on my driveway if he could conduct his business from her property, and he appeared as though there was a language barrier.
Right.
Okay.
So when this incident happened, though, I actually typed up a little note and put it in her mailbox, just asking her for the name and address of her gardeners, because they should have been the ones that we needed to address this issue with, and she chose to ignore my request.
You did receive this note.
I did. So when that went unacknowledged, I said...
Why, just a second, why didn't you acknowledge this letter?
I thought it was harassment.
You did? Why
Yes.
would you think this was harassment?
Because it's been going on for some time.
Prior to December 19th, when had the plaintiffs communicated with you?
I have a dog that I walk every morning. They had acquired a very small terrier, allowing it to go to the bathroom on my front lawn. I ran outside and asked her to never let that dog go on my lawn again, and she grabbed me. I thought that she perhaps would throw me to the floor, to the grass.
When was this, Mrs. Shapiro?
It was last fall. I can't tell you the date.
What month?
Well, we'll say November, October. I don't know exactly.
October, November. Prior to that, had you had any difficulty with the
Yes,
plaintiffs?
they cut the tree. I have pictures here. They cut the crown out of the tree.
When was that?
That was in June or July.
Okay, so you had the tree and you had the dog, months apart. But this letter is very clear. This letter says, please provide us with the name and address and phone number of your gardener because he has damaged our property.
I ignored it because I thought it was more harassment.
Okay, go ahead. What's next?
Well, then I sent her a certified letter return receipt, and she refused to pick it up from the post office. So then I sent one via regular mail so that I would have all my bases covered.
Okay, and you did in fact receive this letter asking for $280.25.
I didn't receive it as certified mail.
No, you received it as regular mail.
As regular
And did you
mail.
do anything after you received this letter?
No.
Okay, go ahead.
Well, then we ended up putting up a wood fence just because we could tell that with no help from the defendant, there was no way we were going to be able to protect our belongings from future damage without preventing them from walking on our property completely.
Let me see.
So this was the $1,400 we spent on the wood
I'm not
fence.
interested in the $1,400 fence. I'm interested in a picture of the
pictures?
fence. Okay, so now you have a fence up, so there's no more problem with the gardener.
Correct.
Good. That saves a lot of trouble. Nice fence. She's not going to pay for it. Put it up, you pay for it.
Okay.
What's next?
We ended up having to put up a chain link fence to protect the rest of our property because there was an incident where some stuff was stolen from the side of our house.
You don't think Mrs. Shapiro did?
No, I know she didn't do it.
Of course. So you put up another fence, and you also want her to pay for half of that fence.
Correct.
But that's not going to happen. Okay. Okay. Now I'll hear you, Mrs. Shapiro, with regard to these holes that were clearly burn marks. Did you discuss it with your gardeners?
I did discuss it with my gardener. I don't see my gardener. They come when I'm at work.
Well, then you have to be responsible for it. If you didn't make an inquiry to your gardener as to what happened, they have reason to at least believe, based upon what they had previously observed and based upon the burn marks that are in their tarp, that it happened as a result of leaf blowing and the hot exhaust coming out of the back of these machines. They asked you, please find out what happened. You clearly responded to them, I'm not doing anything. If you refuse to give them the information, they have no recourse but to sue you. Now I want to get to this tree business, because that's really what I consider the gravamen of your countersuit, which is that they cut down a tree that was on your property. Well, let me hear about it.
They didn't cut it down, Your Honor. They cut the crown out of the tree. That's the center part of the tree that grows the highest. It's a specimen tree. It's full grown. It was given to me by my nephew shortly after I moved into the house. This nephew is a very precious person, was a very precious person to me. He was dying of cancer, and he said to me, Aunt Jeanette, every time you look out your front door, you'll remember me. And so to me, it became a symbol of a tree of life.
Well, let me see what they did, Ms. Shapiro.
This, the pictures, Your Honor, were taken on the early part of March after I received the summons to appear. The damage was done in June or July of last year.
What, was the tree hanging over their property?
Some of the tree did hang over the property, but not that part of the tree.
We didn't trim anything that wasn't hanging over our property, Your Honor. Why would we trim the crown of her tree? That doesn't make any sense.
Real cases, real people. Judge Judy. Karen and Brett Frawley claim their vehicle cover was ruined by neighbor Jeanette Shapiro's gardeners. Jeanette claims the Frawleys mutilated her tree.
Go ahead.
It was a full tree, and now it is in a V. It was even more drastically cut when it was first done. It's had it for 6 months.
Well, it grew back.
Yes, but the crown is gone. You can see
that
the V
may be,
there.
but if the crown was hanging over their property...
It was not hanging.
Well, I can't tell that. I can't tell that.
I understand that.
And if they did that in July, why didn't you register a complaint in July?
Because I thought this was just more harassment. I don't communicate with these people.
Why not?
Because she shouts at me.
Just a minute. You said, listen, in July, this was the first thing that you told me that happened.
It goes further back. It goes maybe a year or two further back, when she called me to her driveway and said to me, I want to talk to you, Jeanette. I walked over there, and she says, tell your gardener not to blow any leaves on our lawn.
So that's not harassment, Mrs. Shapiro.
I said, if you want to talk to the gardener, please, you have my permission to talk to the gardener at any time.
They don't speak English.
I don't know that they do or not speak English.
Well, he said he tried to speak to them, and there was a language barrier. So I assume when he says a language barrier, he means that they don't speak English, because he speaks English. Very unfortunate. In any event, I have no proof that whatever they cut from your specimen tree was not hanging over their property. It's impossible to tell from these photographs. But since you refused to give them the information which would have allowed them to pursue your gardener, you have to be responsible for the damage yourself. You have the bill?
Yeah, it's in that letter. It was the original amount that we had asked her for, the $280.25.
Judgment for the plaintiff, $280.25. Thank you.
Excuse me one moment.
Yes, just a minute.
I'd like to show you a picture of my side of the fence. There are 3 signs that are posted on my side of the fence that say, keep out, no trespassing. That's on a front patio of mine. I would like to have those removed. That's right in direct line of my front door.
Well, maybe her gardeners know by now, and we could take it down.
Well, then let's talk about that, because these 2 signs, keep out, private, posted, are really unattractive. So why don't you take the signs down? It would be nice. She would like that.
Sure.
And I can understand that it faces her front door and it doesn't look nice. This looks like a nice neighborhood. Got it?
No problem.
I got it.
Good. Thank you.
Thank you.
Parties are excused. You may step out.
That tree was a very, very precious tree to me.
We tried to be cordial with the neighbor.
It means a great deal. It was actually a tree of life as far as I'm concerned.
You live and learn, I guess.
Yeah, this is case number 336 on the calendar in the matter of Biggert versus Reed. Parties have been sworn in, Judge. You may be seated. Sir, have a seat.
Mr. Biggert, the defendant is your former wife, and it is
Yes.
your claim that since you've been divorced, separated, and under a child support order, you have overpaid some $3,500 in child support.
Yes.
You say that it was not an overpayment, the money was used for the children, and there was some sort of an agreement for him to pay you additional money. You have a counterclaim for $700 because you say he was ordered to pay $700 in attorney's fees for some sort of a custody proceeding the 2 of you were involved with, and he did not pay that amount. When were you divorced?
1988.
And you have 2 children?
Yes.
How old are they?
Howard is 18 and Sarah is 16.
And what was the child support order?
It was approximately $1,200 per month.
And during what period of time did you overpay?
I'm assuming it was over the whole period, because when I received the paperwork from the court, it just said we did an investigation from the time you started paying child support until the end of August.
So over a 13-year period?
Yes.
And you can't definitively say over what period of time you made these overpayments.
No.
Should have kept better records. Was the overpayment agreed to be reimbursed by the defendant at any time in court?
I was not aware there was an overpayment until I received the paperwork from the court saying they had done an investigation into the child
Let
support.
me see the piece of paper you received. At the time you received this order, it indicates that $3,573.85 was overpaid over the course of 13 years.
Yes.
I'll hear you.
All the money that I got was spent on the kids.
Were you aware of the fact, Mrs. Reed, that you were being overpaid?
Not at the time, no, because the checks always fluctuated.
When did you become aware that you were receiving too much money?
About a month and a half ago when I got it through the mail.
And when did you become aware of the fact, sir, that you had overpaid child support?
When I received that notice in the mail from the
When
court.
did you remarry, Mrs. Reed?
May of this year.
Prior to that, both children lived with you?
Yes.
And did your former husband see the children regularly?
No.
Did you see the children?
At times, but not.
You have a reasonable relationship with your children?
Yes.
Do either of your children live with you now?
I have custody of my daughter,
And how old is she?
16.
Which she does not live with him.
Who does she live with?
My second ex-wife.
Do you pay child support to your second ex-wife?
I reimburse her for any expenses that she incurs for my daughter, or I pay the expenses directly.
Under what circumstances did your daughter leave your home?
I think it was because I finally got help raising the kids, and I think it was too structured and she didn't like it.
Do you work?
Oh, yes. I have a beauty salon.
Are you under a current child support order for your 16-year-old daughter?
No.
How come?
Well, probably when she went to live with her dad, it was all of a sudden, and I was told she was moving in with her father. 3 weeks later, I find she's living with her stepmother. So I was not very happy about that. And no one's ever requested child support from me. But as my income compared to his income, I don't think there would be much anyways.
I'm not so sure.
Well,
how many children do you have?
5.
How many children do you have?
2.
I guarantee you if somebody requested child support, you would pay it.
Oh, definitely.
What kind of income did you have at the time that the children were living with you?
It was about $11,000 a year. So it was like all I could do to keep us in the house that we bought together when we were married, but I wanted to keep the kids where they were raised.
I want to do a calculation for you, Mr. Biggert. Maybe it will make you feel better. Difference of $3,500 over the 13-year period. Do you know what that comes out to, Mr. Biggert? $22 a month.
Yes.
Or $5 a week. So nobody got rich on that difference. And quite frankly, I don't feel justified in saying to the defendant, who really didn't know that she had received an overpayment, now you have to come up with $3,500, unless you can tell me that you don't think that she spent that $5 a week, at least in part, on the children.
Well, I think, Your Honor, that she's probably spent more than that, and I spent more than that over that 13-year period myself.
Right. That's a good thing. Okay. You want to tell me about this counterclaim that you have?
Yes, I've got information that he was to pay for our son being custody changed last year. It was ordered that he pay me the amount of $900.
$900 for what?
The attorney fees for the custody.
What happened with that custody proceeding?
Well, actually, my son come back to live with us, with LG and I, and the 900 attorney fees, it says here, was to be paid to me to pay my lawyer. And so far, Herb's paid 200 of it, and said he would pay me, or if I paid the other 700, he would deduct it from the 3,500 that I owed, and he would only be suing me for the 2,800.
Mm-hmm.
And I just didn't feel that was correct.
What did you
when
feel
the
was
court
correct?
order, because I have a court order here stating that he's to pay it.
You have a court order that he was to pay $900 for your attorney, and he's got a court order that says that he's supposed to pay so much for child support. He overpaid you in child support. You want me to give more recognition to your order than to his?
No.
So why should he pay you a penny?
Real cases, real people. Judge Judy. Herbert Biggert says ex-wife Kim Reed owes for the return of child support. Herbert claims he overpaid and Kim kept the money.
Go ahead.
This was supposed to be paid back in January, and it was not paid.
I understand. Well, that's your counterclaim. He's what?
Your Honor, if I might, you said yourself we were talking about $5 a week over 13 years.
Right. But accumulates to $3,500.
Exactly.
Right.
This court order was basically after the fact as far as paying the attorney fees from a change of custody.
Mm-hmm.
That's why the countersuit.
When was the order?
January 9th, 2001.
Okay. No, he was still paying child support in January of 2001, sir.
Yes.
He was still overpaying child support in January of 2001.
But we didn't know until now.
I understand that. But for you to suggest that I'm going, or anyone would order him to pay you $700 or $900 for your attorney's fees when you have collected $3,500 in excess of this child support award, even over 13 years, is ludicrous. It's ludicrous. Especially, Ms. Reed, since, and I don't know all of the facts, but you have a 16-year-old for whom you are paying zero support.
Because I was never ordered yet.
If a man, Ms. Reed, if a man said that to me in court, I don't have to pay child support because I was never ordered to pay it, I would wipe up the floor with them. You don't have to be ordered to pay support for a minor child. That's your obligation. That's your obligation as a parent.
But I do not have the funds that he has. And
doesn't make any
But
difference.
if my daughter needs something, I do go get her and take her.
No. You don't have to have the same funds that he has. Child support obligations are supposed to be fair. And you have perhaps less funds than he does, and he has more obligations than you do. You have yourself and your husband, and he's got himself, and he has at least 4 children that he's supporting. One is emancipated, but he has 4 children for whom he pays support, including your daughter, who is no longer living with you. So you should be paying something to his ex-wife every month.
To his ex-wife, I would.
Well, then you should be, and you don't have to wait for a court order to do that.
Well,
So
see, I never understood how all this went. When I had both my children, he paid me. When he had Howard, or one of my children, and I had the other, it just got cut in half, and I didn't have to pay for Howard, so I didn't understand that I really should have to pay for her. And knowing that, I have no problem. I just didn't know.
Well, just a minute. I mean, I just want you to think about this. Howard went to live with his father, so he paid you half of what he had been paying.
Right.
Why should he pay you anything?
I don't
Why
know how
should he
the
pay you
system
anything?
works.
Now, you have 1 child, he has 1 child, and you each support the 1 child that you have in your custody. You think it's sort of fair that his child support order was cut in half. To me, you have far fewer obligations, you have a working mate, and if 1 child is living with you and 1 child is living with him, then what you do is you each take care of the child that's living with you. We shouldn't have to pay you a penny. That's fair. I try to be a fair person. In any event, Mr. Biggard, while I am minorly sympathetic with your position, truth of the matter is, if you never got this piece of paper from child support enforcement, you would not have known that you had overpaid over the course of 13 years an additional $5 a week. Correct?
Yes.
You would have been able to sleep easier.
Yes.
Right? Not a big deal. On the other hand, because the money went for your kids. There's no question that if she had an extra $5 a week, she didn't go out and buy herself a sable coat. That be a fair statement?
Yes.
All right. On the other hand, it is the height of chutzpah. You know chutzpah?
I know chutzpah.
To suggest that I'm going to give you any part of your counterclaim after you have been enriched over the course of 13 years, the amount of $3,500. So your counterclaim is dismissed, your lawsuit is dismissed. Go, be nice parents to your children, don't fight anymore, and try to be happy.
Thank you, Your Honor.
Parties are excused. You may step out.
Thank you. When the court determined that I had overpaid, and I thought it was fair to receive the money back.
I spent it on the children.
And now the next case.
All parties in the matter of Aikman versus Ward. Step forward, please.
29-year-old store manager Christine Aikman is suing her ex-fiancé, 34-year-old auto mechanic James Ward, for the return of her belongings. James says she gave him the belongings in exchange for a car.
Ms. Aikman, how long did you and the defendant live together?
6 years.
When did you separate?
We actually separated shortly after Christmas of last year.
And according to your complaint, when he left, he took some property that was yours?
Correct.
And that he owes you for some rent.
Mm-hmm.
And Mr. Ward says he doesn't owe you anything for rent, and that the things that he took, it was a trade-off with a car that you had together. That you took the car, and that was the agreement that he would be able to take certain property. All right, so I have a few questions. When you lived together for this 6-year period, how did you handle the finances, Ms. Aikman?
With his paychecks, he'd take care of rent, other little things. With mine, I'd take care of our cable, our lights, food, necessities.
And how much was the rent?
$5.95. plus gas.
And when you had to buy things for the house, how did you do that?
It would just depend on what money was where, what was left.
So tell me about these things that you say that he took that belonged to you. What did he take?
He took an antique bed that was given to me by my grandfather. My grandmother had passed away. I was also given her...
Okay, so a bed that was a gift to you.
Right.
From your grandmother. Justice. Sure. Let's deal with one thing at a time, please. An antique bed that was a gift to you, not purchased, it was a gift to you. All right, Mr. Ward, let's deal with the bed. You took the bed.
All I have is a box spring and a frame, and it was given to both of us by her grandfather.
When you say
her
a box...
mattress, I left the mattress.
I'm not talking about the mattress. The bed itself,
Just a steel frame and 2 box springs is all
Not
the
a
original
headboard,
bed.
it doesn't
Not
have a headboard?
No headboard, no nothing.
Is that right?
Yes, it is.
Give me a break. What kind of an antique frame? I never heard of an antique frame. I heard of an old frame, but I never heard of an antique frame.
She's had it forever.
Oh, Miss Aikman, give me a break. Move on. What's next?
All right. I also have a 27-inch color TV.
Now, where did the 27-inch color TV come from?
I purchased it with my tax refund about 4 years prior.
4 years ago while you were still together?
Yes.
While you were sharing your money?
Correct.
Okay. What's next?
There's also the antique, or the quilt that my grandmother handmade that I cannot replace.
Quilt? Where's the quilt?
It's not an antique, it's store-bought.
I don't care.
And she said I could have it with the bed, with everything else.
Yeah, she wants her quilt back.
Okay.
We'll put it in a box and send it back to her. It came from her grandmother. What's next? One quilt. What's next?
And the color TV.
How many TVs did you have?
We had one that worked and one that didn't. He conveniently left the one that didn't.
What else did he leave?
Well, the bedroom set that was given to me, he actually left that.
Bedroom set?
Yes. Washer and dryer. He left me my kitchen.
Kitchen set?
Actually, he took the kitchen table and chairs, but he left me my dishes, my pots and pans. He did leave all that.
So far, what's the vision in my head is that what you get back is the quilt. What's next?
And the back owing in rent that he left when he left in the middle of the night on January 27th.
Now, had you paid January's rent, sir?
No, I haven't. I made arrangements with the landlord, gave him a 30-day notice.
When did you do that, sir?
January 1st.
Well, that's not 30 days notice if you left on the 27th.
I gave him the 3rd. I told him the 3rd of February.
Okay. And
I
so
moved out earlier.
Show me the proof that you paid January's rent, because that was your arrangement. You were going to pay the rent. She was paying.
I haven't paid it yet. I
Your Honor.
made arrangements with him. I needed the money to move into another place.
So you haven't paid it yet?
No, I haven't.
All right, so so you owe her. All right, now how much did you have to pay?
I had to pay $710, Your Honor.
Let me see. And what the rent was what the rent was $595, is that right?
Plus gas.
And how much is the gas?
$73.57 plus $20 late fee.
Your Honor.
What?
There was a $250 deposit on those apartments.
Okay.
That I should at least be entitled to discount half of that.
They were only going to give back $100 for cleaning since they left it trashed.
Who left it trashed?
They brought 3 kids to the apartment after I moved out, and when they vacated on the 27th.
How much was the security deposit that was left?
As far as what I know and what the landlord told me, there probably wasn't going to be much left.
Well, that you have to proceed with the company anyway. You know you owe her this money. You said you needed this money to move into a new apartment. You owe her the money because your responsibility was to pay the rent. She paid for all the other bills. You were there practically the entire month of January, so that was your responsibility.
Right.
The rent. Other than that,
I also paid the electric and the cable bills.
All right. Listen, after 6 years, don't bother me with nonsense. Will you please? Okay. You get your quilt back because that was an antique. Tell me about this car. When did you purchase it, sir?
In 1999, we got it financed.
And you both paid for that car?
Yes, we did.
Is that right? And you now have the car?
I do. Because I was the only one that was licensed and insured on that car.
Doesn't make any difference, but you both paid for it and you have the car.
Right. Okay. Because when I took my name off the leasing, they gave him 10 days to get a driver's
Honor.
license and insurance.
Your Honor, that's
Just a
totally
second.
false.
I'm not listening. Did I look at you to speak?
No.
I was the only one insured.
I don't care. What I'm saying to you is, let's be fair about this. You had a car that you drove as a couple for 2 years.
Correct.
You each paid a portion of what it took to maintain that car and to pay it off to finance it.
Correct.
Is that right?
I'm still paying it off. Yes.
Well, that's fine, but during the time you were both paying for it.
Correct.
You now have the car. You're getting the benefit of some of his payments for the car. Is that right?
That's right.
So why should he give you the last month's rent?
Because I was kind enough to let him stay in the apartment, not kick him out when he didn't sign the lease. He
Just a
hadn't
minute.
signed the lease.
He hadn't signed the lease. What difference did it make whether he signed the lease or not? He was paying the rent. So my question to you is, for 2 years, you each contributed to the monthly payment on a car.
Correct.
And how many years do you have left to pay on the car?
November, I believe, of this year, it will be paid off.
Fine. So now you have a car to which he contributed over the course of 2 years. Is that right?
Correct.
So you get nothing for rent. Goodbye. Have a good life. Have a happy life. Have a safe trip home.
Parties case number 378 on the calendar in the matter of Nelson versus Perry. Parties have been sworn in. Judge, you may be seated. Ladies, have seats, please.
Mr. and Mrs. Nelson, the defendant is your former son-in-law.
Yes.
Married to your daughter. Is this
Yes,
your daughter? They were divorced and they have children.
Yes,
How many
ma'am.
children do they have?
4.
Your lawsuit claims that, pursuant to the judgment of divorce, your son-in-law was court-ordered to pay 60% of, among other things, child care costs for
Yes,
the
ma'am.
children, so that your daughter could work.
Yes, ma'am.
And that it was decided that you would be the child care providers for the children.
Yes, ma'am.
And that your son-in-law owes you for child care. Your daughter works off her 40% of the child care by working in your family business.
Yes, ma'am.
Okay. Son-in-law says the choice of child care provider was unilaterally taken away from him. And I'll get to his defense in a moment. When were you divorced, sir?
Last year, November 7th.
And at that time, was your wife employed?
Yes.
And who was watching the children at that time?
The hours were set up to where I watched them when she was at work and she watched them when I was at work.
That's not true, Your Honor.
Just a minute. And if there were ever any problems with babysitting, who babysat for the children?
Her parents or my mother.
Why don't you step up here for a moment? Okay. How old are your children?
I have a 3-year-old, twins that are 8, and a 9-year-old.
When did you make arrangements with your parents to babysit for your children?
While we were married, there was a lapse in between our shifts, and my parents would come out for an hour and a half until I got home. And then when he moved out, I needed them to come at 11:30 p.m. and watch them all night long until I got home at 9 o'clock in the morning.
When they came for that hour and a half, prior to the two of you separating, were they paid any money?
No, they used their gas and everything to come out there for nothing.
I just asked you. They weren't paid any money.
Sorry.
They came out to take care of their grandchildren.
Right, they did.
And then, when you were working at night, they would come to your house to sleep?
Right.
And you didn't ask for any money from your daughter, did you?
That was when we started being actually paid cash for the babysitting.
Who paid you cash?
Well, the logic of the divorce was Bill was to pay part of it and my daughter was to pay part of it.
Was that discussed with Bill?
It was court-ordered, ma'am.
No, it was not court-ordered that you were to be the babysitter. That's not what I asked you.
No, it was
I
not.
asked you, were you paid any money?
No.
And when was it that you began to be compensated?
When the divorce was final.
In November?
In November, and we had to take over watching the kids on a 40-hour basis.
When for the first time was it discussed with your former son-in-law that you were going to be babysitting for your grandchildren and expect payment?
I have never discussed that with my son-in-law as far as a cash payment, ma'am. When we were first babysitting for them, when they were still married, the agreement was he would keep our vehicles in running order for our business because that was his line of work in exchange for us babysitting the children.
You mean you had actually an arrangement as far as that was concerned?
Yes, ma'am.
As grandparents?
Yeah.
You had a business arrangement, a
Yes.
barter arrangement. You would barter, he took care of the cars at the times that you filled in for babysitting.
Yes, ma'am.
Okay. And what was your daughter doing for you in exchange for babysitting for your
She
children?
works at our donut shop.
What?
We have a donut shop. Sometimes she comes in and she'll fry, sometimes she'll ice. Other times, if our vehicle isn't running, we use her vehicle to deliver with.
Who had a conversation with him with regard to your taking over full-time babysitting responsibilities starting in January of 2001? You did.
Yes. Actually, Your Honor, my parents didn't start watching the kids again until the end of May.
May of what year?
This last year.
And what conversation did you have with your former husband about your parents taking over that responsibility?
At the time, he wanted me to let his girlfriend watch the kids. I didn't feel comfortable with that, and I found a friend that would watch it for $440 a month total, and he wasn't comfortable with that. That left me with no other choice but to go back with my parents. And I discussed it with my parents. They told me to tell him that if he would come over and keep the maintenance up on their vehicles, that would be the deal. He said, no way. He refused. He got upset.
Well, you got somebody who was not related to you to take over the babysitting responsibilities, you know, during the overlap time for $440 a month. Your parents want how much? 1,000?
880.
880. Where did you come up with that figure?
Well, because we would have to drive to Star and watch the kids there. We would have to bring the youngest one back to our house so that we could continue taking care of the things we had to do. Then we would have to go back to Star to pick the kids up after school. And then we would have to go back to our place so that Tammy could come over and pick them up. And we would take the kids to all their doctor's appointments or anything they had to do at school.
They're grandparents. That's what grandparents do. What was wrong with his fiancée?
Well, I have a letter that she gave me telling me my kids weren't wanted. I have him on tape telling me that he doesn't want to see his kids. And I went to pick him up one time when he had them for the weekend, and they were all in the house. Him and her were in the bedroom taking a nap, and my 2-year-old was 3 houses down by himself, heading towards a busy street. And I just didn't feel comfortable with her having them on a regular basis.
If that happened, that's a very good reason. You're absolutely right.
Real cases, real people. Judge Judy. Linda and Floyd Nelson say their daughter's ex-husband, Bill Perry, owes for his share of daycare costs. Bill says Linda and Floyd are the babysitters, and he doesn't approve.
Now, what was wrong, Mr. Perry, with this friend that she got to watch the children for $440 a month?
I do not know these people, Your Honor.
You may not know them. Did you say to her, I'd like to meet them? I'd like to meet this friend, spend some time with this friend before I agree?
No,
did you say that?
No, I did not.
Why not?
At the time, I had my fiancée, which was willing to watch them.
That's not a good idea. So, Mr. Perry, while I am sympathetic with your position that your in-laws have overcharged the amount, I do think that you were being short-sighted and got a bug in your bonnet when you said, forget this stranger, because your former wife, who's the mother of these 4 children, I am certain would not want to leave the children with anyone who was not capable of babysitting for them. And just because you say, well, I have somebody who's going to do it for a lot less, my girlfriend.
Your Honor, Your Honor?
Yeah, I'm waiting.
I never claimed to not want to pay the person she has talked about.
Mm-hmm.
If I would have received a bill in the mail, I would have sent my money to them. I said I had somebody else that could babysit my
girlfriend.
Correct.
Listen to me, Mr. Perry. Put your hand down. Listen to me, Mr. Perry. If you said to your former wife, I'm married, I am in a solid relationship, we've been married for a year or 2, she stays home, she likes the children, they like her, this is going to be a forever thing as far as I'm concerned, let's try to save as much money as we can, my wife will take care of them. I assume that your marriage to your former wife was your first one, is that right?
Correct.
It didn't work out 4 children later.
Correct.
Now you have a girlfriend.
Hmm?
There is even more of a likelihood that this isn't going to work out with your girlfriend forever. I think she is perfectly justified in saying, I don't want his girlfriend to babysit for my children. Put your hand down. By the same token, Mr. and Mrs. Nelson, I think it's overreaching. I think you're overreaching a little bit. I think that what you're doing is saying to your daughter, listen, come and put a little frosting on the cake every once in a while. You work off your 40%. We want to be good people. You know, we want to be good grandparents. But you really don't charge your daughter for her 40% of this child care bill. But if you had somebody to babysit for your children for $440 a month, he would be responsible for 60% of that. Okay. It's about $264 a month that he would be responsible for. That's pretty reasonable, isn't it, sir?
Yes, it is.
Good. That's what he's going to pay you for babysitting.
That's fine.
Good. May, June, July, August, September, October, November, and December. It's 8 months. $2,112. So from now on, Mr. Perry, if you don't want to get into any difficulty, it seems to me that you make those payments on time. She says, fine. Not they. I'm not interested in the plaintiffs. Your wife said that would be fine.
Right.
Right?
Right.
And she's the only one who is a party to the court order ordering you to pay 60% of the daycare. Do you understand?
Yes, sir.
So right now you owe them $2,112, and I suggest that you keep that money up every month as long as they take care of the children. That's all.
Parties are excused. You may step out.
He didn't want to have anything else to do with her, nothing to do with the children.
If they would have sent me a bill on daily or a monthly basis, I probably would have paid it.
He's seen him 4 times in 6 months. I can't help it.
One of the children is not his biological child, and he has to pay child support and daycare on that child.
He hated her. He didn't want to see the kids.
Didn't go like I thought it would, that's for darn sure.
And now the next case.
All parties in the matter of Schmidt versus Neves. Step forward, please.
27-year-old financial advisor Ray Schmidt is suing his former friend, 28-year-old waitress Christy Meaves, for an unpaid loan of $1,000. Christy says they were much more than friends, and the money was a gift.
Mr. Schmidt, you claim a loan to the defendant in the amount of $1,000. The defendant acknowledges that you gave her $1,000. She said it was just that. It was a gift from a friend. So tell me when you gave her the $1,000, what it was for, and how you know her.
I originally met Miss Mavis in early part of June. I was introduced through a direct selling company, and our relationship kind of grew from there. We did become friends. We saw one another at different functions, and the way it happened is she and I became friends. And
just social friends, not romantic friends.
No, just social friends. And
that's not true.
Just a minute. Through the course of our relationship, she promoted my business, and she got me a few clients. I actually have a copy of the account apps for these clients that she helped get me.
Did you pay her for her service?
No, ma'am.
You never went out socially, is that right?
That's not true. We did go out socially, a group of us. After meetings, we would go to have cocktails after meetings.
How many people in this group?
Usually anywhere from 6 to 10.
So it was a large group. So you weren't intimate social friends? You never went out to dinner alone together?
Yes, we had.
Oh, you did that too?
Yes, ma'am.
How many times did you go out for dinner, just the two of you?
Never dinner, a few lunches.
But never dinner?
Never dinner.
Never dinner. That's fine.
Okay. So that, would there be any reason why she would perform a business function for you that was financially remunerative for you without billing you?
Yes, because we were friends.
So now let's get to the $1,000 and the why.
She wanted to open up a direct sales office in Las Vegas. And when she went to go do this, she was a little bit short on cash. So I offered, let me loan you the $1,000.
Who brought up the amount?
I asked her, how much do you think you'd need?
Okay.
So it was agreed that she would pay me $500 2 weeks, because we got paid on a 2-week basis through this company, and then the other $500 the next 2 weeks after that.
And she went and she didn't pay you back the money?
No.
And that's why you're here. You have anything else to tell me?
I did, because she brought me these clients, I did, in fact, purchase a dress for her. It just so happened that...
That's the dress, I assume. I didn't know what that show and tell was. Go ahead.
So here's the receipt for that.
How much did you pay for the dress?
It was $64.86.
Okay. Now let's hear your version of the events, madam.
Yeah.
Can you do me a favor? Put the schmata over there. Go ahead.
Okay. I did meet him through a mutual friend that brought him into our office. That's true. And yes, I did help him get clients because he was a very nice young man when I met him. He did try to pursue me in a romantic way, and he had a girlfriend at the time. So for quite some time, I wasn't taken by it. However, he told me that he broke up with her, which later I found out from her calling me that they never broke up. But I did bring in one of the loving cards he gave me as just a business friend, and I don't know if you'd like to read that.
I'd like to see it.
It's definitely not just a friendship card.
Ray, remember this
Your
card? Shh.
Yes, ma'am, I do.
Okie dokie. It's hard to find a love like this, a sharing love, an honest love, a love that's so rare, so beautiful. This is a business friend.
She helped me through a tough time. She had some books and some insight, and that was able to help me take my life to another level.
So you owed her a lot.
Yes.
Now,
So
I read the
basically-
card. Keep it going.
Yeah. So basically, when I was thinking about moving to Las Vegas, he offered to lend me this money. At first, I was like, no, no, no. And then he told me he believed in me, so he was going to give me this money. I came back to Newport Beach, and one of his friends told me that he was back together with Lana. Now, I'd pretty much talked to him every single day, probably a couple times a day. It was, you know, we had grown a relationship. I basically got very upset about it. I was out with him and one of his other ex-girlfriends, who I was actually helping him with for the business. Yeah, he stays friends with a lot of those. And she was the one who told me that him and Lana were back together, and I was like, So basically, I just decided at that point I just wanted nothing to do with him anymore. And then I got a phone call from Lana who told me that they never broke up.
Let's go back a little bit. When you first started to speak, you said he offered to lend me this money. Shh. He offered to lend me this money. Now, I think that at that point, when you said that, you realized that you misspoke.
No, I turned him down.
What did you say to him?
I was a very proud person. I didn't want to take his money.
Is that what you said?
Yeah.
You said, I'm too proud, I don't want to take your money.
Yeah, I've never taken money from anybody.
And then what happened?
He said he wanted to give me $1,000.
Yes.
That was when he told me, I believe in you. And I told him, okay.
So what you're telling me is you're basically a very proud person. You've never taken money from anybody, but you were willing to take this as a gift, but not a loan.
Because I really liked him.
Miss Meaves, Mr. Schmidt may not be a very nice person. He may have deceived you. He may have deceived the old girlfriend. He may like to string along a lot of ladies at one time, but he loaned you this money. You know he loaned you this money. I now know he loaned you this money, and that the reason you decided not to pay him back this money was because you felt as if he was deceptive and didn't deserve to get it back. Because if I believe anything that you say, you want me to believe everything that you say. So if you tell me that you are a proud person and you never take money from anybody, then that kind of person would have said, I will accept a loan from you that I will pay back, but I'm not accepting a gift from you because that would mean that I was not a proud person.
Right.
And doesn't take anything from anybody. So I don't believe you. Anyway, judgment for the plaintiff in the amount of $1,000. That's all.
Now, this is case number 12 on the calendar in the matter of Pierce versus McCombs Pierce. Parties have been sworn in. Judge, you may be seated. Ma'am, have a seat, please.
Mr. Pierce, the defendants are your daughter and son-in-law.
Yes, ma'am.
Your lawsuit consists of two parts. The first part has to do with an old debt, and that is a debt that stems from purchase of a washer and dryer. Several years ago, according to you, your daughter needed a new washer and dryer. You agreed to put it on your credit card, and according to you, the arrangement was that they would pay the credit card charges. You ended up paying for the whole thing because they were paying sporadically.
Yes, ma'am.
And they've never paid you back for that.
No, ma'am.
Second part of the lawsuit is you claim that sometime more recently, either or both of them used your ATM card without your permission and withdrew, I believe, $2,700?
It was actually just a little over 25, ma'am.
And you want that money back?
Yes, ma'am.
How much was the washer and dryer?
The actual purchase price was $726.
Okay. Who wants to talk?
I will.
Go. Let's start with the washer and dryer.
Washer and dryer, I was told that it was going to be a gift to us for our wedding.
Who told you that?
Sue and Chuck.
Really?
Yes.
When did they tell you that?
It was the day they bought it.
Did you ever tell them that?
No, ma'am, I did not.
Now, I don't care, sir, whether you didn't know that this was a loan because your wife didn't tell you, because I've got her answer. But don't lie to me, because clearly this was never given to you as a gift, with a statement by your father-in-law that it was a gift because your wife acknowledged that it wasn't a gift. Is that right?
That's correct.
Now, she may not have told you that at the time.
I found out about 2 weeks ago.
I understand that. But don't lie to me and say he told you it was a gift.
Well, him and his wife both told me that it was a gift.
Why would they tell you it was a gift when it was not?
I don't know.
Did you have some sort of an arrangement with your daughter not to tell him?
No, ma'am.
Now, what arrangement did you have with your father?
I had told my mother and my father both that I would make the payments, and then Mike and I ended up splitting up, and I could no longer make the payment.
So they bought the washer and dryer when?
Around the end of '97.
Okay. And you and your husband broke up when?
Around the beginning of '98.
Had you made the payments up until that time?
I'm pretty sure, yes.
Is that right?
Yes, ma'am.
Okay, so?
And so I told him I could no longer make the payment, and I told him he could have it back if he liked.
Well, what was he going to do with it?
I don't know.
Whatever he wanted.
Well, how much do you think the store was going to give them for a used washer and dryer?
He was so
He could've
desperate to get it
sold it.
back. He had more than an opportunity to come and pick it up.
What was he supposed to do with it?
Whatever he felt like, he could have put it on top of his house.
What do you do
He
for a
wanted.
living?
I'm a delivery driver.
What do you deliver?
Newspapers.
I mean, don't you fail to see the logic in your response? Let me ask you this, sir. You own a car?
No, ma'am.
Did you ever own a car?
Yes, I have.
Did you buy it yourself?
Yes, I did.
Did you buy it new or used?
It was used.
Did you pay it off?
Actually, yes, I did.
So let's say you buy the car January 1st of 2000, and you buy the car for $1,000, and you drive it for 6 months, and you find that you can no longer make the payments. So you say, I'm going to take the car back. Now all the debts is cleared. That's it,
No.
I'm taking the car back.
I never had any written.
No. Just pay attention to what I'm saying to you. You think that that's what a car dealer does? Takes
No.
the car back and say, thank you very much, you couldn't afford it, we're really sorry.
No.
No, because once you take out a car, it depreciates in value.
Yeah, and I have a written agreement also with the car, not with the washer.
You don't need a written agreement, sir. You don't need a written agreement to have a contract. You can have an oral contract as long as there is an offer, which was made, and acceptance. That's what makes a contract. See, I just taught you something. Now, when did you get back with Mr. Charming?
I don't know, it was probably like 7 months later.
So 7 months later, you got back together. Did you start to make the payments then?
I don't believe so, but I think it started in December of last year till either February or March. I was making payments to my mother of $50.
Is that right?
Every day.
I believe so.
So how much did she pay off in total? You have to tell me, sir. She
Um,
sounds to me like she made a lot of payments.
Actually, probably, I would guess, probably $700 or $800.
That would pay off the washer and
Just
dryer.
a minute. That paid off the washer and dryer. If you're guessing. Did anybody keep receipts? Anybody keep money?
I don't handle the finances in the family, ma'am.
Well, who does?
My wife does.
Where is she?
She's at home at work.
Forget washer dryer, as far as I'm concerned. You did the right thing, according to your father, and if you paid off $700 or $800, he's guessing, and you don't have any records, I assume the washer and dryer is paid off. See, you're home free. Now, who took the ATM card?
I did.
Why?
Because me and my wife were in some financial problems.
Well, tell me how you took the credit card.
I got it off the kitchen counter.
You walked into your in-laws' house and you just took it off?
Yes.
Did you tell your wife about it?
Yes, she knew about it.
What'd you tell her?
I told her that it was something that we discussed, and we put the
Tell
money...
me what the discussion was, Mr. McCombs.
That we would take their card, take the money out, and then put the money back as soon as we had it. And that's exactly what we did.
You stole money.
Yes, and I put it back.
You stole money. How did you get caught?
I guess he got his bank statements and noticed that there was a couple withdrawals on there that weren't from him.
Show me the money that was withdrawn by them.
Here's the copies of the actual bank statements. And the amounts are highlighted, ma'am.
How do you know that these are their withdrawals?
I'm a long-haul truck driver. I'm not home during the week. And as we determined, they were all done at approximately the same time.
I see. 7-Eleven. Is that where you took the money from?
No. Took it from Washington Mutual Bank, their bank, to avoid a surcharge.
Where did you take the money from?
Washington Mutual
I'm not
Bank.
asking you. Where did you take the money from?
I believe I did it once, and it was at 7-Eleven, I would believe.
Father agreed not to prosecute these charges. Is that right?
Apparently, yes.
What do you mean, apparently, yes? What does that mean?
We're here and not there, so apparently...
We're talking about a long time ago, madam.
Yes.
And what was the arrangement with your father with regard to him agreeing not to prosecute?
Mike made the arrangements with my mother. And my
Which
mom
was?
Ask him.
I'm asking you.
That he would be responsible to pay them back the money.
Now, why isn't your wife here, sir?
She was unable to come down because of her job.
Is it possible she didn't want to come down here and confront her daughter?
Could have been.
Did you discuss that?
Yes, she was hoping to be kept out of it to save her relationship with her daughter.
Time to bring up.
Excuse me?
No, just a talk her and her mother had last night.
Which was?
Which is, if I didn't stand up, he would make my mother choose between me or him.
Who's he, your father?
Yes.
Parents been pretty good to you?
Her mother.
Her mother?
But she wasn't asking you.
That was the smartest thing I've heard you say. That was the smartest thing I've heard you say so far. You probably ought to say it more often.
Real cases, real people. Judge Judy. Charles Pierce says his daughter Rose Pierce and her husband Michael McCombs owe for a washer and dryer. Charles also says they used his ATM card to steal money.
Now, your arrangement was that you would take responsibility. You have a memory lapse with regard to how much money you took out of your in-law's account. The fact that you stole from them and you knew that you were stealing from your parents is really an outrageous thing. I know that you probably paid a lot more in service charges and credit charges over this 726 with regard to the washer and dryer. However, Mr. Pierce, since you don't keep good records and your wife is not here, and since your daughter did in fact make an attempt to pay and did, according to you, pay at least $700 or $800, I am wiping out that debt. However, I find that they are responsible for unauthorized withdrawals from your bank account in the amount of $2,536.50. That's all.
Parties are excused. You may step out.
Just happy to see justice done.
It's pretty sad. You have to come to court for it.
I expect people to honor their word and pay their debts like they should.
And now the next case.
All parties in the matter of Summer versus Bree, step forward, please.
53-year-old property manager Stephen Summer is suing the mother of his son's former friend, 49-year-old nurse Jan Bree, and her son, 17-year-old Joey. Stephen says Joey, together with his son, 16-year-old Chris, stole his credit cards and ran away.
Mr. Summer, it is your claim that your son and the defendant's son stole your truck, stole your credit cards, took some cash out of your house, ran away to Vegas or something, had a spree. Not once, but twice. And you want the defendant to pay for half the damage to the truck, half of the credit cards that they built up on this little jaunt that they had, and also half the cash that was taken from your house.
Correct, Your Honor.
Okay. So, for the time being, I just want the two boys right up where you are, and the parents can sit down. All right, so let's get to the first occasion when your father's truck was taken. Tell me about that, Christopher.
I was in my house, and Joseph was staying over at my house, and I just was fed up staying at home, so I wanted to leave and asked him if he wanted to come, and so we left.
And tell me about your father's credit cards.
I took a couple of his credit cards.
I want to know how you did that.
Out of his wallet.
Where was his wallet?
In our office, I think, Your Honor.
Who went into the office?
I did, Your Honor.
Alone?
Yes, Your Honor.
And what did you do with the credit cards?
Put them in my pocket, and then we left.
Where did you go?
Towards Las Vegas, Nevada.
Did you ever end up there?
Yes.
When was the first time you used the credit card?
A couple hours after that night in Anthem, Arizona, at a bank, Bank of America.
And how did you use the credit card?
We stopped at an ATM and withdraw some money.
You stopped the car.
Yes.
And when you got out at the ATM, what did you do?
We had the money and then we left after that.
When you say we had the money, where did Joseph stay?
He was in the truck.
He stayed in the truck while you went and withdrew the money.
Yes.
And then you kept going.
Yes.
When did you next use the credit card?
At a gas station, maybe 3 hours away.
So all told, you used the credit card and you stayed at a motel?
In Las Vegas, yes.
And then did you go home?
Yes.
Voluntarily?
We stayed at a halfway place and then our parents came to pick us up.
Did the police stop you?
Well, we came out of the hotel and the police were waiting there.
And then your parents came and picked you up?
Yes.
I would assume that they had a serious discussion with you when you got home?
Yes.
But then you got bored again?
Yes.
When did you get bored again? How much later?
A month later.
So tell me what happened.
I was there and then I just got tired of it and so I left in my dad's Mazda truck.
And when you left in the truck this time, did you take any of your father's credit cards?
Yes.
Where'd you get them from?
His wallet.
Again?
Yes.
And where was his wallet?
In his bedroom.
And where were the truck keys?
The truck keys to his Mazda was in his pants pocket.
And where was your father when this was all going on?
He was sleeping.
So what time did you leave?
11 o'clock that night.
And you went and picked up Joseph?
Yes.
Well, tell me what happened when you got to his house.
I got to his house and I parked alongside of his road, walked up to his house and his light was on. And I went and knocked on his window and he had his stuff and so we left.
What stuff?
Some clothes and...
Well, had you made arrangements with him before to
Yes.
take off again?
Yes.
Well, tell me about that. When did you call him and tell him you were going to take off again?
Earlier that day.
What did you say to him and what did he say to you?
I just said I wanted to leave and asked him if he wanted to go and he said yes.
And you took off again. Where did you go this time?
Towards Chicago, Illinois.
And how many days later did you get stopped?
3 or 4 days later.
And you used your father's credit cards all during that time?
Yes.
And you got stopped by the police again?
Yes.
So, Joseph, you want to tell me how come you went along for the ride twice?
I was in a lot of trouble, and I was in trouble with my girlfriend. I was in a lot of trouble at home, and just kind of wanted to get away from there because I had nothing to lose, that kind of stuff. That's about all. Rebelling, I guess.
Now I'll take the parents. No, you stay up there, Christopher. You're involved. Mr. Summer, did you have any conversation with Mrs. Bree with regard to her repaying you for any of the damages to your truck or anything else?
Yes, Your Honor.
Tell me what kind of conversations you had with her.
Basically, Your Honor, I summarized all the charges and accumulated all the debts and payments and everything that were expected, and I put together a concise list that I expected to have Joy reimburse us for his 50%, and I felt they were equally responsible for these events. And I presented it to her and asked her that she review them, present them to Joy, get his approval or disapproval, have him sign a promissory note to repay all of the charges, and I would continue that debt to be paid.
And what did she say to you?
She said, I'll go home and we'll review it.
Mr. Summer, let me tell you what my feelings are. I read your complaint very carefully. The defendant's answer suggests that her son was just along for the ride. Well, I don't think that's entirely true, Miss Bree. The problem that I have, Mr. Summer, with your complaint is that while you may not have been on notice the first time that your son had a propensity to steal your property, certainly after the first runaway, you were on notice. And it seems to me from what your son tells me that you took no extra precautions, like putting a lock on your car so that it couldn't be started, like making sure that the keys to all of your vehicles were at a place where he couldn't get them, to securing your wallet, because it would seem to me that but for the fact that all of these things were left as accessible to him as they were the first time, he wouldn't have been able to get into the car and to make arrangements with Joseph to run away again. I mean, I'm not saying that he exercised good judgment. I mean, you have two idiots. They're two idiots, but they're two 17-year-old idiots. You have the ability after the first runaway to secure your cars and secure your cash and secure your cards so that your son wouldn't be in a position to do it again. And I know it's a terrible way to live, but for the fact that these things were so accessible, we wouldn't be here today.
They were inaccessible, Your Honor, in my estimation.
How were they inaccessible if you did it?
The keys and the wallet were in my pants, and they were at the head of my bed, and he had slid into the bedroom in the dark and broken down a lamp that had a hook on it, and he hooked the pants and slyly dragged them out of the room and confiscated and took the keys to the Mazda.
Did you get your life straightened out?
Yes, Your Honor, I have.
Have you?
Yes, I have, Your Honor.
You two boys still friends?
No, Your Honor.
You going to school?
Your Honor, I went to a quasi-military camp for 5 months, Your Honor, and I graduated from high school with my diploma and my GED, Your Honor.
Okay, and what about you?
I am still enrolled in school, Your Honor.
Going?
Yes.
Still got the same girlfriend?
Yes, Your Honor, I do.
Haven't run away since?
No, Your Honor, I'm a explorer for the Phoenix Police Department now.
Well, at least they got you involved in something. Anyway, Miss Bree, let me tell you what I believe you are responsible for. I believe you are responsible not for $2,500 worth of charges for all of that, but I believe that your son used half of what was spent on the credit cards just for their jaunts. He knew it was the wrong thing to do. And he spent, and he ate, and he slept, and he drove in a truck that had gas, and that's going to cost $187 because that's half of what the credit card bills were. It's judgment for the plaintiff. That's all.
And now the next case.
All parties on Denon versus Avales. Step forward, please.
40-year-old poet Cheryl Denon is suing her ex-boyfriend, 38-year-old steelworker Thomas Aviles, for the down payment on a car. Thomas says the vehicle was a gift in return for teaching her to drive.
Ms. Denon, according to your complaint, you met the defendant while you were online in a chat room. And at the time you were married, you began a relationship, I assume, on the computer with the defendant. Is that right?
Correct.
And then there came a time when that relationship developed. You ended up terminating your marriage, or your husband terminated your marriage. And while you were in this relationship with the defendant, after you and your husband separated, you claimed that you loaned the defendant $2,500 as a down payment for a new used car.
Correct.
That's not true. Shortly thereafter, you decided that he wasn't right for you, and you terminated the relationship with him. You and your husband are now back together. You want your $2,500 back.
Correct.
When did you first begin to have this chat room relationship with the defendant?
I would say about December of 1998.
Okay, and when did you first meet him?
Possibly maybe 2 or 3 weeks later.
And when did you and your husband separate?
We separated in 1999.
When in 1999?
August.
At that time, did you begin a relationship with the defendant?
We had a relationship going on and off the whole time.
Okay.
And the reason for my husband leaving was because of that.
When did you give him this $2,500?
December of 2000.
When did you separate from him?
About 3 days before Christmas.
So within weeks of giving him the $2,500, is that right?
Correct.
And tell me about the conversations that took place prior to you giving him the $2,500.
Well, we discussed that we were, quote unquote, going to be a couple, and that he was going to teach me how to drive.
You didn't know how to drive?
No, I don't know how to drive. And he was going to help me regain some independence, which was good. And at first it was spoken that when I lent him the $2,500 that he was going to pay me back.
She said it was a gift.
Shh. Don't.
He said that he was going to pay me back when he got his income tax. Then, like maybe a few days later, we talked about, hey, well, we're going to be together. What's yours is mine.
Who said that?
Both of us.
So you said that?
No, I didn't.
Yes, you did, Tommy.
No. You said that. You said you both said it. So you said it. What's yours is mine, and what's mine is mine. Right?
Yeah.
Well, isn't that the way it works? I can't say it any other way. What's yours is mine, and what's mine is yours? That doesn't even sound right. Okay. Did you have any discussion with him about the $2,500 when you decided to terminate the relationship?
Yes, I did. He came over to my house maybe before New Year's, and he had Christmas decorations in my window, and I was not home. He took all the Christmas decorations out of my house that he had put into my house, which I would have returned them to him anyway. I did not want to keep them, okay?
Okay.
And I had come home, and he was there.
Well, did you ask him at that point about your $2,500?
Yes, I did. And he said to me, don't ask me about that if you want to be friends with me. And I thought that was very stupid because I was not going to be friends with him. when there's other circumstances why I didn't want him that I found out later through the relationship.
Okay. Mr. Avalos.
Yes.
Let's talk about this car. Under what circumstances do you claim that she gave you this $2,500?
Your Honor, we had a deal. You know, we had a car accident. We had mentioned in my car.
What do you mean we had a car accident?
She was in the car with me in my van, and we had a car accident.
But you were driving?
I was driving.
So you had a car accident?
Okay, well, she was in the car with me.
She was in the car with you, but you had the accident?
Yes, Your Honor.
Okay.
Okay, so at that time, she made a suggestion, why don't you go buy a new car? And I said, where would I get the money for that? She said, well, look, let's make a deal. I will give you the $2,000 for a down payment, and you will teach me how to drive, and it'll be our car. I said, sure, that would be fine.
Okay.
Okay, so we go to the dealer, we pick this car out. I said, I really can't afford it. She says, look, I'll help you with the payments. I said, oh, you sure about this? She said, yeah. Now, she gave me $2,000. It wasn't $2,500.
I assume she's going to be able to show me that she took out or she wrote a check for $2,000.
No, she gave me cash. She gave the dealer cash.
I would assume you have the receipt for that. Does somebody have the receipt for what you gave to the dealer?
Sales slip has been returned.
To where?
To that dealer. When I took the car back, saying I can no longer afford this car.
How much was the entire purchase price of the car?
$5,000.
Is that right?
Correct.
So on Christmas Eve night, I had a call from her husband stating the fact that she's back with him now.
Okay, so they're back together.
And he would be around to pick up her things. So they came around the 26th, picked up things that she had at my house. Her husband had stated on the fact that he was going to come around and pick up the things, said, keep the car. We don't want it. If they were going to pick up half the car or come and get the car, they would have came and said something to me on the 26th.
Did you just say they're going to come and pick
well,
up
you know
half
what I'm saying.
No, listen to me.
Okay.
Look, you're not receiving.
Yeah, sure.
Did you just say to me that if they were going to pick up half the car, they would have come and picked up half the car?
I meant to say, if they were going to say anything about the car, he would have came around on the 26th and said, we want the $2,000 back.
All right. Mr. Avalos, listen to me. You just cooked your own goose. You said to me, your agreement with the plaintiff was this was going to be your car as a couple.
Right.
And she was going to, according to you, put down not only $2,000, but also help you with the car payments.
But they told me to keep the car. They said they didn't want it.
They don't want the car.
Right.
They don't want the car.
So I took the car back.
What do you mean you took the car back? You never gave it to them.
No, I took it back to the dealership.
Fine. And what did you buy?
A cheaper car that I could afford.
How much did you pay for the cheaper car?
$4,000.
And how much later? 3 weeks after you purchased it?
Yes, about 4 weeks afterwards. It was in January.
Like to say you're right. All right.
It was in
so
January.
4 weeks after.
Yes, Your Honor.
You brought it back. How much did the dealer give you for the $5,000 car towards the $4,000 car?
$2,500.
All this you don't have any proof of. You have no paperwork, you have no nothing.
I have the owner's card.
You know you're coming to court. You know, usually people bring paperwork when they come to court.
He kept the paperwork for the other car, so I don't have the paperwork for the new car.
Copies. So if you have paperwork for the new car would have shown how much money he gave you for the old car.
True.
Good. Now you're getting better. So you used, according to you, $2,000 of her money to purchase this car that you are currently driving.
Yes.
And according to you, Mr. Avalos, this was supposed to be your car as a couple, right?
Yes, but on Christmas Eve, she devastated me. She said she no longer wanted to be the couple, that she wanted to take the car back.
How do you think her husband felt?
Well, he's the one that told me, he said, keep the car.
I wasn't talking about the car. I was talking about his wife.
They were divorced.
Because of whom?
Not because of me.
Because of the two of you?
Not really.
That wasn't because of you?
No.
When you started to
they
have
had
this...
problems long before I came.
Well, that's what she told you when she was talking to you in the chat room, but they were still married, right?
True.
True. All right. You got to give her $2,000 back. Judgment for the plaintiff in the amount of $2,000. That's all.
This is case number 441 on the calendar in the matter of Hoffman versus Hoffman. Parties have been sworn in, Judge. You may be seated. Folks, have seats, please.
Mr. Hoffman, the defendant is your mother.
Yes, ma'am.
And I've tried to understand your complaint as well as your mother's countersuit. You claim that you sold to your mother certain restaurant equipment, a freezer and some other equipment, and that she owes you money on that equipment.
Yes, ma'am.
Your mother says she's not only paid for that equipment, the freezer doesn't work, and not only doesn't she owe you any money, but you actually owe her money.
Yes, ma'am.
All right. What was this equipment? Where did it come from? Why would you sell it?
Actually, I owned a restaurant in Salisbury, Maryland. Was getting out of the restaurant business.
I had been working 16, 18 hours a day. It was just too much. I was losing my marriage, my 2 small children. Had called a restaurant equipment place, set up arrangements for them to come and buy all the equipment from me. My mother steps in and says, let me buy the equipment from you. I may want to give it a go. I mean, you've worked so hard putting this business together from the ground up. We'd hate to see, you know, the family lose this.
What kind of a restaurant was it?
It was a carry-out sub pizza and deli type restaurant.
Okay. Were you making any money?
A little bit of money, not a lot. It wasn't worth all the time we had to put in. Put out a lot of bills, put out over $30,000 for the equipment.
Okay. Did she give you any money?
She gave me $4,000, signed a bill of sale for a list of equipment, which I have here.
I'd like to see it, please.
That's also a copy of the bill of sale.
So she purchased, according to you, all of this equipment for $8,000. According to this, she gave you a deposit of $5,000.
That was correct. I only actually received $4,000 cash, Your Honor. $1,000 I gave to her to help her with startup costs.
This says, this contract of sale says $5,000.
Yes, ma'am.
With a balance due and owing of $3,000.
Yes, ma'am.
That's what it says. And then it says that you additionally sold her a freezer for $3,000. Did she pay you anything towards the freezer?
No, ma'am.
Okay, Mrs. Hoffman, let me hear from you.
Hey, Your Honor. This started out, Joe told part of the truth. This started out, my son had 3 businesses in Salisbury, Maryland. He was losing his family and his businesses because of a crack cocaine addiction. I stepped in, being his mother, trying to help him save at least this one business. He reneged on his lease, was locked out of the building. He could not get to his equipment. I paid the money for Joe to get into the building, the $1,000. That's the $1,000 that Joe was talking about. I didn't want this business. I quit my day job 2 years ago to enjoy my farm and my horses, Your Honor. I was trying to help my son. I wanted my son to seek counseling for his drug addiction. He's lost everything.
All right, so you agreed to go into his business to save the business.
Yes, ma'am. Hopefully that he would get it back.
Okay. Did you sign a contract with him with regard to the equipment?
I signed this. Joe told me the same thing that he gave you. I have the notarized copy and the serial numbers. Okay. The $1,000 a month, because I thought, he showed me his books, he was making $90,000 in 6 months' time, that I would be able to pay back this at $1,000 increments. I have registered tapes to prove documentation that I only make, some days, only $50 a day.
Mrs. Hoffman, that's not his problem. That's something, if you're going into a business, you're supposed to check the books very carefully.
I trusted my son, Your Honor.
Well, that's a problem. How can you trust your son if you say he's got a serious drug problem?
I know.
And clearly you were dealing at arm's length with him with regard to this transaction, because you drew up a contract, you drew up serial numbers for all the items. This was not a, I'm going to help you out, I trust you. This is business here. Let me see your books. He showed you his books.
Showed me his book.
Showed you his book. And according to his book, he made a lot more than certainly you were making.
Yes, ma'am.
Did you have an accountant go over the books?
No, ma'am.
Did you have somebody come and sit in the restaurant every day for about a week to see what kind of traffic there was?
No, ma'am, I didn't.
Well, that's what you do if you buy a
foolish.
restaurant. That's what you do if you buy a restaurant. How much money do you still owe him on the equipment?
The freezer wasn't due a payment until March.
Of 2002?
Yes, ma'am.
Oh, so you don't owe him anything really on the freezer because the payments aren't due yet. Is that right, sir?
That's not correct, ma'am. She defaulted on the rest of the loan. I was due a payment December 30th, as per the signed notarized agreement of $1,000. The freezer was lent to my mother.
No, sir. This says she was to pay you in increments of $1,000 until paid. That's for the freezer. Starting March 30th, 2002, until May 30th, 2002, a total of 3 payments. So
Yes,
she
Your
doesn't
Honor.
owe you any money yet on the freezer.
And it was verbally between myself and my mother that I would allow her to pay the freezer after she paid me for the rest of the agreement.
Doesn't say that here, sir.
That was verbal when she drew the contract up.
Let me
Your Honor.
explain something to you, sir. When you have a contract, anything outside the contract that's verbal, courts don't consider. Courts say, forget it, so strike the freezer. She's got a little bit of time before she has to pay that first $1,000 payment. Now, what else do you owe him?
The refrigerator is leased. The leasing company has contacted me. Joe owes money on that. And I found out yesterday morning that they're coming to pick up the refrigerator unless I can pay him for it. And the signs on the building, I've had to pick up that bill because Joe told me that the signs were paid for, and I've had to pay that. And I feel I don't owe him any money because everything I've had to pay out. That was his bills.
Real cases, real people. Judge Judy. Joseph Hoffman says his mother, Doris Hoffman, owes for the cost of restaurant equipment. Doris says Joseph is a crack addict, and buying the equipment was an attempt to save his business.
Go ahead.
My mother knew that there was 2 leased items. One was a refrigerator, one was an ice machine. She knew exactly how much the leases were. We sat down at the kitchen table and figured out how much the bills would be for the leases. She knew there was $300 owed on one sign, $300 owed on the other sign.
How long had you had this business, sir?
I had the business for just about a year, Your Honor.
Okay. Tell me something about your counterclaim, Mrs. Hoffman.
Your Honor, I don't feel I owe Joe the money. I feel...
Owing, I'll take care of in a minute. You have a counterclaim for $4,900.
Yes, ma'am.
For what?
It's for bills and that I've had to pick up and pay his because they were going to take the signs off the building. A microwave that he had a piece of aluminum foil in for the fuse to keep the microwave running. It's for 2 car top signs that he sold me. And yes, Your Honor, I did know he owed $350 on one, but I did not know about the 2 exterior signs that the man was there to take down off the building the day I opened my door.
That you should have known. Mrs. Hoffman, it's always a problem when you're in business with family.
Make sure you get everything in writing.
No, you're supposed to know. If you're going into a business venture, you're supposed to exercise due diligence. If you looked into all of his books, you would have had to have seen payments that he was making to a sign company, right? You would have had to have seen payments that he's making for equipment. And then you say, what is this for? All right, let me see the contract. How much was it originally? How much is owing on it? And then you make a judgment. And you can't say, well, I trusted him, he's my son. This is a business venture. Your mother doesn't owe you for the freezer yet. Now, with regard to the other payments, those were supposed to be completed for the remainder of the equipment by next month.
Yes, ma'am. She's on a payment plan. She's already missed December's payment, and January's payment is coming up.
Well, it says for 3 months starting in December. Did she pay you December's payment?
No, ma'am.
And that was for $1,000?
Yes, ma'am.
And then January's payment, she didn't pay you?
No, ma'am.
But that's not due yet?
That's correct.
Is that right?
That's correct.
So far, she only owes you $1,000.
That's correct.
Judgment for the plaintiff in the amount of $1,000. That's all.
Parties are excused. You may step out.
It hurt very much to have to bring my mother to court, and I hope that she can finish paying me the money she owes me so we can get our families back together.
A lot of things didn't come out that should have came out, and my son does have a drug addiction problem.
And now the next case.
All parties on Shaw versus Jones. Step forward, please.
50-year-old Bonnie Shaw is suing her former friend, 42-year-old bartender Sherry Jones, for the value of items she sold at a garage sale. Bonnie says Sherry pocketed the money.
Miss Shaw, you and the defendant were friends, is that right?
Yes.
And according to your complaint, you gave her some things to sell at a garage sale.
Yeah.
These were things that you originally had at a garage sale that you had at your house.
Correct.
That you were unable to sell.
Correct.
It is your claim that she either kept the stuff or sold it and kept the money, and you want the value of the property that you gave to her to sell.
It was garage sale items and other items that she had borrowed, and I brought her son with me, her abandoned son, who can testify that to the quantity of items.
When did you have your garage sale?
In September and the beginning of October.
Over how many days?
5, 6.
And where did you get this stuff from?
It was 5 generations worth of items, plus relatives and neighbors gave me things. It was massive amounts, Your Honor. Furniture, some antiques, bedding books, clothing for every age, sexes, sizes, dishes, household items, thousands of items.
Explain to me how the property came to be in Miss Jones's possession.
When the sale was over, she told me to rent a U-Haul. She would bring it to her house. She had a great location. She said that she could sell sand to the Arabs and snow to the Eskimos, and that she's had several yards.
that way.
Shh, don't speak. You'll have a chance. Go ahead.
So I upon her insistence, rented a U-Haul truck and drove it to her house. Her son was there, helped unload it. She ran the sale at her place. When I asked about money, it was one excuse after another. At that time, I did not realize that she was planning on disappearing from town again. A few things were returned.
What did she return?
A few books. I had well over 1,000 books. She returned some. Your Honor, this is a little more complicated than just yard sale stuff. I mean, this lady has the habit of ripping everybody off. She disappears, she leaves town, she abandons her child.
Miss Shaw, that may be interesting. This is a court.
Understood.
You have to prove a case. Did you make an itemized list of everything that you gave to her in the U-Haul?
I have a generalized list. It would be
I'm not
impossible to
interested.
itemize all the thousands of items, Your Honor.
Well, then how in the world am I going to make a decision? Generalized list is no good. You check off from the list. I mean, that's business. I assume you were in this to make money, right? And to unload a lot of junk from your house.
It wasn't junk, Your Honor.
Well, there's
Yes.
a lot of stuff in there that, madam, listen to me. I know why people have garage sales. I've had those. But a lot of stuff out, and you hope that somebody wants to buy you a 15-year-old sled or children's ice skates or some picture that you can't look at in your house that's, you know, that's there, sometimes an old frame that has a broken glass. I know what goes out in garage sales. This is not an estate sale, but you have to have a list. Here, you say you want the return of value of personal property, and you say it's worth $1,625. Well, that's a very specific amount. And how do you come up with that specific amount if you have no specific list?
The letter I wrote to her has specific items in it.
Well, let's see. Let me take a look at the specific items.
That's the letter she totally ignored. I advised her that I would take her to small claims court unless she returned the items or the value thereof.
Mostly you talk about in this letter about things she borrowed from you, not about the things that she allegedly took for the garage sale. You sold well over $582 worth of goods, yet I was only reimbursed $82. Then you go on to talk about a shelving unit that you loaned to her, a blue shelving unit. When did you loan her a blue shelving unit?
Before the sale. She wanted to have it to set things up on it. And it was reiterated repeatedly that that was not for sale. I wanted it back.
So where is that?
Your Honor, I have no idea. I left some things in the garage when I left. There was like a shelving, there was an old broken door, a broken window. Furthermore, when she says thousands of items, there was a lot of them she left at her house that didn't even bring over to my house. When the stuff was returned, half the time she was sleeping.
How many times did you return some things to the house?
I made at least 12 carloads from my Monte Carlo.
Her son will attest to what was there. He knows that she was bragging one day of over $600 that she brought in from the sale. I did not receive this
That's
money.
A lie.
You want to step
That's
up?
a lie.
Just a minute.
I never took his $600 for no.
I'm talking
Just
about
a
my
minute.
600.
You're her son? Who do you live with?
I live with my stepfather and this lady here.
Had you been living with your mother?
I was until she decided to leave.
And then you moved in with the plaintiff.
Me and my stepfather moved in with
So when she left, her husband moved in with the plaintiff.
after she left.
Shh, I don't want to hear from you.
He couldn't afford it anymore with just the two of us there, so she offered to help us out, and we've been living there.
Is your stepfather renting a room from her, or do they live together?
No, we rent upstairs there.
So the two of you sleep upstairs?
Yep.
Now, what do you know about this property?
I remember books and some clothes and stuff like that.
How many boxes of books do you remember?
No, not off the top of my head.
All right, let's get back to the things that you say she borrowed. A fancy lace black slip top.
The borrowing that top was for an anniversary party, and the dress that's mentioned is also in this photo.
Did you borrow dresses from her?
No, I didn't, Your Honor. It's a black dress. She had in her garage sale before her belongings left the garage sale. My daughter gave her $1.50, and she accepted it. As far as the black cami lacy thing, yes, I have that. I was told not to go near her house. I was told not to call there. How do I give it to her?
Borrowed slippers. What are the borrowed slippers?
Your Honor, I know this all sounds really trivial. And
It does sound trivial, madam.
I mentioned that in the letter to her, but what you have to understand is that I am not used to being ripped off like this, especially by a friend. This was all a con on her part to line her pockets. She'd been planning on leaving town for months, and nobody
Madam,
knew about it.
You say it sounds petty. It certainly does. My white hamper that belonged to my grandmother.
Yes.
Well, when did she borrow your white hamper?
In September, October.
What'd she borrow your white hamper for?
So one of the kids could have a place to throw their clothes.
One of her children?
Yes.
Then that's not borrowed.
It was on loan. She was going to
please.
get something else.
Oh, please. Come on. Come on. We're talking about nonsense here. Borrowed purple sheets. What would she borrow purple sheets for?
For her bedroom, she wanted to change the look.
And you're saying that they're borrowed?
Yes, ma'am. It was the whole set.
Just a second. I never had a friend that I said, "Here, you can use my sheets, borrow them, and then you can then give them back to me when you're finished." Miss Shaw, you're angry about something.
I am not angry, Your Honor.
And it may be that she ripped you off. That's very possible. But if you're in business, then what you do is you inventory. She gave you, you say $82. Well, according to this young man, according to your witness, the only thing that he recalls emptying out of the U-Haul were boxes of books and old clothes. And it's very possible that you gave her more stuff. But without a proper inventory, I cannot help you. No, that is not an inventory.
There was a stove. There was...
He doesn't remember unloading a stove.
He's probably as nervous as I am.
Well, you don't look nervous at all. And he's not nervous at all. If he had to take a stove out of a U-Haul, that would be something that you would remember, which he didn't tell me. Miss Shaw, whatever problems you have with this lady, I would suggest we get over them. And it's very possible she sold stuff at her garage sale that she had and didn't give you the money. The court can't help you unless you keep records.
I understand that. There was
Good.
just way too many items to mention, and her
Then
own
I
son can
can't-
attest to the money
if
that she
there-
bragged about getting.
If you can't itemize what they are because there are way too many items, I can't help you. Period. Goodbye.
Your Honor, this is case number 358 on the calendar in the matter of Stenger versus Stenger. Parties have been sworn in, Judge. You may be seated. Folks, have seats, please.
Mrs. Stanger, the defendant is your former daughter-in-law.
Correct.
Who is this?
My husband.
And who are you?
I'm Tasha.
How old are you, Tasha?
18.
You're the granddaughter.
Yes.
And you?
Jennifer.
Who are you?
I'm the partner of Deborah, 6 years.
Deborah.
Yes.
Okay. This is your lawsuit. It is your claim that your former daughter-in-law was having some trouble with Tasha. She called you and asked you if you would let her come and live with you. Your granddaughter did come to live with you. You claimed that your daughter-in-law promised to send you support for the child. She did not, and then your granddaughter took off from your house and went back to her mother's house.
That's basically correct, yes.
When did she come to live with you?
January 12th.
And when did she leave your house?
I noticed her missing the morning of July 16th.
Did things go all right between you when she was there?
Basically, yes, we had a couple normal teenage things, but other than that, Tasha was a wonderful child.
What was your arrangement with her mother with regard to support for Tasha when she was living with you?
When we got home on the 12th, Debbie was there with Tasha. She explained to us that she was having some problems with her at home and then asked us to take her in, and if we didn't do so, she was going to turn her over to foster care. So we took her
That's
in.
untrue.
We made arrangements that day that, you know, she would take care of her financially.
Well, no, tell me exactly what was said.
She never actually named, per se, a dollar figure, but she just led me to believe that she would meet her financial needs, and I just took
But you
that.
never discussed an amount?
No.
How much did she send you from January to July?
In the beginning, she brought over money orders, totaled $270. What I was getting was actually the child's father's support money. What happened was it ended up getting frozen, and then from
how
that,
much money was she receiving from your son?
$44 a week was payroll deducted.
Was there ever a conversation that she would turn over his child support payments to you?
Yes.
Did you ever discuss any money in addition to that she was going to pay you?
No. When we needed help, when I would call her, like how she needed some medical treatment, I would call and leave messages on her answer machine that I needed up and beyond what the insurance was going to cover. She never would return any phone calls.
Where was your son at this time?
He was there.
There where?
About 5 miles away, and he came over 2 and 3 times a week and spent quite a deal of time with Tasha.
Why wouldn't you call your son and tell him that she had some medical bills?
I called both, and he did end up giving me money.
Okay.
Total of, in the 7 months Tasha lived there, he gave me out-of-pocket money, $700.
He gave you directly?
Yes.
$700. And she gave you $270?
Yes.
And did she give you any more than $270?
Never.
Now, you say the child support at some point became frozen. When did that child support become frozen?
It started on February the 1st. I just simply asked the question to my son, do you have to pay child support money to a child that no longer resides at that address? And he at that point didn't even know the answer, so he called his caseworker and asked. And I guess that's what started it rolling. And then a notarized letter from Deborah on 2/20 states that the child was residing with me, and they just, after having heard from both parents, just froze the money.
And so the money kept coming in?
Kept coming in, but was not going, and to this day has never been released. There was, on October the 17th, there was a court hearing. And to my knowledge, what money was supposed to have been frozen while Tasha was in my care was supposed to be, according to this paperwork, turned over to me. But as of today, I've not received one dime.
Well, but you will be receiving.
According to the child
Let me
support...
see the, let me see the paper that you
flip down
have.
to that. According to what they have told us, she was actually entitled to.
The impounded funds shall be released to Jean Stenger. That's you.
That's right.
So you will be getting that money.
At least the $600, yes.
Okay. Now, is there any discrepancy in what your mother-in-law has indicated to the story that you would tell me?
Yes, absolutely, Judge.
Let me hear.
I did correspond with Jean on taking some family intervention with my daughter. When Jean volunteered to take Tasha, there was no monies per se as an amount to keep her. I did tell Jean, providing that I did receive her father's child support, that I would indeed turn that over to her. Jean is correct on stating that the child support was impounded on February 2nd. Due to the child support being impounded, it froze my other daughter's child support also. I have another daughter. So while both child supports was impounded, I had to write a letter, as Ms. Stenger said, to get the child support released.
For your other daughter?
For my other daughter. Tasha's child support was indeed impounded.
Okay.
And I could not turn over the monies to Ms. Stenger.
Do you work?
Yes, ma'am.
What kind of work do you do?
I work at Sears and I'm at shipping.
How much money do you get for your other child for child support?
I receive $44.12 per week per child.
And how much do you earn?
I bring home about $700 every 2 weeks. But in January, I fell on my back. I was off work for 14 weeks, and I received 50% of my pay. I was bringing home $250 every 2 weeks.
Okay. Mrs. Stanger, your lawsuit seeks $3,000 from the child care expenses.
Right.
There has to be an agreement, which there clearly was not, other than the fact that she would turn over the child support payments to you.
Well, she did lead me to believe that she was going to care for the child. She didn't move her into my home with the understanding that I was going to meet all financial debt.
Right, well, you wouldn't have. She was getting $44 a week from your son.
Mm-hmm.
Clearly, the $44 a week that she was getting from your son doesn't cover child care expenses, even when the child is in her care. So she has to use her income as well. She says that she was receiving half disability for a substantial part of that time.
That is correct, Your Honor, but that's not the whole story. According to all of these, this is the police reports that took place within their home. She was couldn't go back to work, according to the police reports, because she had to go to drug rehab.
That is a lie.
Real cases, real people. Judge Judy. Jean Stenger says ex-daughter-in-law Deborah Stenger owes for child support costs when her granddaughter lived with her. Deborah says she gave Jean all of her child support money.
Mrs. Stenger, whether the injury at work was drug-related or not, if she could not work for that period of time, then there was no additional money coming in.
Right.
So let me tell you what would have happened, Mrs. Stenger. She could have gone back into court and pursued additional support for Tasha from your son. Stop shaking your head, because it's a possibility. I know. I was in family court for 25 years, sir.
But he didn't have a job, so he was hurt.
So you as parents pitched in and took care of your granddaughter.
Well, the only thing, I incurred so much expense. Number one, I had to take her back and forth to school, round trip 4 times a day, 80 miles a day. She had to have $3 a day for lunch money.
I understand that it was difficult, but that's what grandparents do.
Well, you don't mind
And
it,
you
but when
wouldn't-
you're abused.
And you wouldn't be here today, Mrs. Stenger, were your son still married to the defendant.
No.
Of course not. And you're not suing both of them. You're choosing just to sue your former daughter-in-law.
Well, I felt because she had full custody of her, and we had virtually an agreement that that's where it should go.
No, virtually an agreement is not an agreement, Mrs. Stanger.
Because I didn't have her put it in writing?
No, you said it was my understanding that. And I believe what she said to you was, I will turn over the child support payments to you. So in addition to giving you the child support payments, she also gave you a little bit of extra money, $270. But that is not an agreement. It's not an agreement that is binding in a court. So you have a son who's not working, because why?
He has a heart condition and is still under doctor's care as of today.
So?
Well, what we're saying is he was working 3 jobs and they made him quit. Okay?
Made him quit all 3 jobs?
All but one. He could remain to do it because he could do it out of his own home.
So you have a son who can hardly take care
afford.
of himself, and you have an ex-daughter-in-law who's got 2 children, who was really paying the lion's share of support for both children for a long time, because on $44 a week, you don't take care of a child.
That was only after, what do you want to call it? The child support was had a reduction done in it. He was actually paying $134. I have a court printout where he paid her $100,000 over the time period from the day of the divorce.
Since when?
Was actually, when were you divorced, Debbie? 87?
So you're telling me from
1987
1987 he paid her $100,000?
Yes.
So?
Well, I'm just stating that he
So?
paid more than $44 in
What
that
I'm
time
telling
frame.
you is, so?
Oh, I understand that.
Doesn't come out to a lot of money. Sounds like a lot of money. Paid her $100,000. If you sell me, paid her $100,000 in the last 2 years, in the last 3 years for the support of 2 children, I would say. Okay, you know, man's doing his job. But since 1987,
yes, I know.
If he's paid her $100,000, that doesn't cut it for me.
How many years was it? 14 years.
What about
14, I'll figure it out what it is for you. All right, my trusty calculator. 100,000 divided by 14 divided by 12 equals $595 a month. Divided by 4.3 is $138 a week. Divided by 2.
No, 3.
3 at that time.
You mean she had 3 children?
Yes, in the beginning.
Well, glad you told me that. That's even less. So forget it. You got $1,500. But I have a sense that one of the reasons that you're here is because you're angry because your granddaughter left your house without so much as a goodbye and a thank you or goodbye, I'm going back to my mother. Step up. Did you have a fight with your grandmother?
I had a few little fights.
Well, the last one. You left sometime in July. Why?
I got tired of hearing her and everybody put my mom down as she was a bad person.
And they did this to you, in front of you?
Well, they did it in their bedroom or in the living room or when I was in the room, like I was invisible, you know. It didn't matter where I was.
That's a big mistake. That's a terrible mistake. You're absolutely right.
That is not true. Conversations were not held in front of the child. That's not true.
Well, listen, may not be held in front of the child, but if they're held in a room where she can overhear them.
That didn't happen.
Well, that's what she says. What do you think happened? Why did she leave?
Number one, we got a phone call in regard back to the child support. On July 5th, they called. Debbie had kind of rapport with them, and she had been in their office on that day, and when she left, they had informed her on that day if she would get letters from both the children, they would release the funds. July 7th, Debbie started showing up at my home. Tasha was with us for 7 months. During that time frame, Debbie never one time called me or my husband and asked how the child was doing, if she was in need of anything, nothing. Like I said before, when I needed the help with the medical bills, Tasha had came to us. She had a root canal that needed to be done, an abscess on her tooth. Debbie did carry insurance, but when it came time for the insurance check to come around, the insurance company mailed it to Debbie. Debbie took the funds and cashed the check and never refunded, never paid the dentist, never. And that's a lie. I have the bill from the dentist.
That's not a lie. Why did that happen?
When the check came to me?
Yes. What did you do when the check came to you?
I cashed it and I bought Tasha socks, underwear, and shoes.
Wrong! Wrong!
Absolutely.
That was wrong.
Yes, it was.
So, how much was the check?
$89.10.
You owe her that. You want to buy your daughter underwear, you buy your daughter underwear.
I didn't pay that. I didn't have a root canal done. I didn't have anything done. I still have
The child to this day hasn't had the root canal. The infection in her tooth was so bad, they placed her on antibiotic, and I took her, as they requested, to a medical doctor. And well, what I'm saying to you, it was in her blood system. They said that it wasn't life-threatening yet, but it could get there. And if I hadn't got her help...
That's a dangerous situation, I'm telling you, that you want to take care of that.
And it was one that I got placed in the middle of.
What?
The tooth has been pulled.
The tooth has been pulled?
Yes. Yeah. Thank heaven.
Well, that's cheaper than root canal, just to pull out the tooth. Where was the tooth?
My
wisdom's going
back
to take her
molar.
Didn't the dentist tell you that it would be better to do a crown and to do root canal work on a young child's mouth rather than pulling a tooth so that the whole mouth shifts? See, it pays to have a father who's a dentist. Didn't he tell you that?
Yes, ma'am, but I didn't have the $562.
Get it! Get 2 jobs. Get 5 jobs. Okay, so far I have that you owe her $89.10.
The only out-of-pocket expense, as far as for debt, she needed a new book for school for one of her classes, $27.10.
So you bought your granddaughter a book. I'm not so concerned about buying your granddaughter a book. Listen, if the reason that you left your grandmother's house is because you heard her and your grandfather saying things that were unkind about your mother, that was a tremendous mistake on their part, not on your part. But if you wanted to be a little more grown up, you would have said, I want to go home to my mother.
That's all she needed to do.
One time, and they said that I couldn't leave.
That's not true. She never.
They said that you couldn't leave. Why?
Because I lived there, and my grandfather would not let me leave.
You mean you felt like a prisoner? Is that what you felt like?
Oh.
No.
It didn't happen. I think this letter here that she wrote
Did you go out with
herself
your friends?
explains why she left.
You never went out? In the 7 months you lived there, you never went out with friends?
Once a weekend, if that.
Fine, so you went out with your friends. Doesn't sound to me like you were a prisoner.
She went anywhere and everywhere she wanted. I seen to it she did.
Okay.
And I think this letter that she actually wrote here actually explains why she left. She thought she was going to get that money, just like I stated, from the child support, and they was going to spend it on those things.
Okay, good. She starts out with, sorry the letter's so sloppy, but dear Granny and Grandpal, I'm sorry, it's been great and all, but it was time to go home a long time ago. You don't get me or understand me. Well, that's probably true because grandparents don't get foolish teenagers. Maybe someday you will. And I know my mama's not perfect, but she is my mama and she needs my love. And I need hers. That's an honest feeling. I hope that you both know that I love you very much and I'll be back tomorrow for my things. It's not about how much you did or are doing or anything like that. It's just that nothing has changed in my heart. Your granddaughter says to you she knows she needs her mama right now.
And she should.
And that I will always have you. And she tells you what I'm getting a new job and a cell phone. She's made plans for school.
And all those plans have fallen through.
And she ends the letter by saying, I'm not dumb and you know that I will be thinking of you twice on everything. And then she says, Angel's love is always with you all. This is not a mean letter. She's just saying, it's a teenage letter, and she's saying, I love you, but I love my mama, and I have to be with my mama, and you don't really get my mama, you don't like my mama. You may not like her style, but she's my mama, and I need to be with her right now. And perhaps it could have been handled differently, Mrs. Stanger, but that's not the way it was handled.
No.
So.
No, I think that's the whole thing in a nutshell.
I gotcha. I understand.
Since that time, we've not heard from her at all.
Mrs. Stanger. Children need the widest possible community of love and affection that they can possibly get, even when they're 18 years old. And clearly, your daughter has had a lot of ups and downs. Fair statement? Clearly, when a mother gives up physical custody of a child to someone other than a parent, it's saying that there have been problems that I can't cope with. And the fact that her grandparents said, fine, we'll try, is a testament to them. Not something that should make you angry with them if they did some foolish things while she was there by letting her little pitchers overhear conversations. That was the wrong thing to do. But basically, they had reasonable hearts because they said, you know, she's our granddaughter and we love her, let her come and disrupt our otherwise calm household. When a teenager comes into your house, your whole house turns upside down. It never is the same. So your grandparents loved you enough to say, come live with us. And your grandmother drove you back and forth to school. It was a big drive every day?
Yeah, it was.
Could she have said to you, if you're going to live here, you have to go to school locally?
Yes.
Of course she could have. She could have said, listen, I'm not driving an hour each way to get you to and from school. I want you to live with us, but you'll have to finish high school close by our house. But she wouldn't do that because you got your friends. You wanted to finish high school where you were, so she extended herself. It's time to put a period and not be so angry, okay? Will you try?
I'm not angry.
Are you angry at her?
Oh, no. No, not angry at all.
Good. I'm glad. Your lawsuit's dismissed. That's all.
Your Honor, this is case number 340 on the calendar in the matter of Carver versus Wilson. Parties have been sworn in. Judge, you may be seated. Ma'am, have a seat, please.
Miss Carver, the defendant is your sister.
Yes.
You were incarcerated.
Yes.
For how long?
Probably a year and a half.
And then you were released to a halfway house.
Yes.
From what I gather, you and your sister had been sort of estranged for a while you were in jail, and you discussed with your sister moving to Colorado, her moving to Colorado, and getting an apartment or a house together and sort of building a life together.
Yes.
And she did. She relocated. You were in the halfway house. You found an apartment together, signed a lease together, and then something happened and you were not released from the halfway house.
Correct.
You believe it was something that your sister had told your probation officer, but in any event, your sister, you say, forced you to pay.
Yes, she did.
Your half of the lease.
Yes.
Even though you weren't living there.
Right.
And that's what your lawsuit is about.
Yes, it is.
Explain to me how that's her fault.
When this started out in June of 2000, we discussed the move with her coming to Colorado. And I paid the money for the house. And she came shortly after. I had like one weekend there with her, 4 hours each day. And
you were allowed out of the halfway house 4 hours a day?
And that particular weekend, we had an argument, and I told her she was not going to be able to smoke her marijuana because I was on provisions that where I could not be around drugs at all because my problems were drug-related in the past. And it seemed to be a big effect. She said no, she wasn't going to quit it. She'll smoke out in the yard. Well, it wasn't soon after that that my case manager called me into his office and told me that he was going to cancel the whole thing and that I would not be able to get out of the halfway house for a time. He didn't tell me how much time, but I had to stay at the halfway house and I could not get out. So I was crying and very upset, and I said, well, okay, then I can't get out. There's nothing I can do. Can you get a roommate? And she said, yeah, sure, I'll get a roommate. And then shortly after that, my case manager called me in again and told me that I had to pay half of the rent. And I called her back and asked her, why? Why is this? I thought she was going to get a roommate. She told me she would, and she wouldn't even talk. She was just really nasty to me on the phone. And I do have proof here that I did pay the rent, and I also have proof that I was not liable for the lease because the lease wasn't even an issue whenever I rented the house. There was no lease on the house, but she insisted to the landlord to make up a lease because she needed it for housing authorities to help her pay her rent.
How much did you pay altogether?
I paid like $2,400 altogether. I paid the initial $1,600 and another $16, so $32.
$1,600 was what for security?
The original. That was the first payment on the house, which was first in security. I've got that receipt here. Then I've got 4 more receipts for 4 more months of half of the $800 month rent, which is $400 each month.
All right, Miss Wilson. I want you to tell me only what happened as a result of your sister telling you she could no longer come to live with you because she wasn't going to be released. So that was beyond her control.
Well, I've got emails that shows our correspondence, and she told me that I told her she needed to find me a roommate if she couldn't live with me, and I gave her the...
She doesn't have to find you a roommate. Why couldn't you find your own roommate? Why wouldn't you want to find your own roommate?
Well, because I had health problems, and it was very complicated. Also, we mentioned the... and I did smoke pot at the time. I do no longer do that. That was stupid, and I don't want to be a bad influence on my daughter.
So, who else lives in the house?
Just me and my daughter. My son was there at the time.
And how old is your son?
My son is now 17.
So that there were 3 of you and 1 of your sister.
Right.
Why should she pay half the rent if she's only 1 person?
Because she agreed to. When I came out, we had a limited amount that we were living on, $512 a month. And I told her this is what I could afford to pay every month. She could have found a cheaper place. I couldn't even get housing authority to okay this house because it was so bad. The floors were caving through. There was cracks in the wall. I fell through the steps and hurt myself. I couldn't get housing to okay it. So I got out as soon as I could, which was in December. She paid for 4 months, which is $400 each month, which is $1,600.
But what about the $1,600 security?
I paid. I've got the receipts. I paid my half.
And how much was your half?
My half, there was $800 security. I paid $400. And $400 for the first. So it was the first and last. And I paid the deposit myself. She didn't pay any of the deposit.
I've got a receipt that I paid the first and last right here
right.
from the landlord.
And I've got a receipt that shows I paid her back for my half.
Okay. I have this and this from the landlord.
And I've got the lease in her name that she signed before I got here.
What efforts did you make to find a roommate?
To be honest, I didn't, because the house was so run down. And I
but you did not?
I didn't.
Okay, can I see the receipt that you gave her for the $800?
It's all stapled in a pile, and I got the emails too, and I highlighted the parts that I was talking about. And they turned her down to get out because they told me she was a flight risk, because I called them myself.
That's not true.
She wasn't released.
That's correct.
So there was an impossibility of performance of her for the contract.
The whole deal with her was to get a place that housing would okay so that I could get their help, and they would not help me with this house.
Otherwise, I wouldn't have made her liable if I could have gotten
Do you have
help.
anything from housing that says that the house was inappropriate?
No, because they gave me, it says that the windows have to be secure, that you have to have fire alarms, that the floors have
Whatever,
to be...
because the landlord suggests that you lost your security deposit because the house was left a wreck.
Yes. No, I cleaned the house.
No, the landlord suggests that you lost your security deposit, and I assume you didn't sue the landlord for your security deposit back.
Yeah, I'd only paid $200, so no, I didn't.
You only paid $200?
Yes.
I paid $800.
Well, she paid $800.
No, we paid first and last. That wasn't a security. I mean, he might have worded it that way, but when I gave him notice, he used that last $800 for my last month's rent.
I understand that. He may have used it, but that was her money.
Well, yeah, it was half her money.
Real cases, real people. Judge Judy. Terry Carver says her sister Julia Wilson owes for the return of rent. Julia is countersuing, claiming Terry used her identity when she was arrested for possession of crack.
All right, let's get to your counterclaim, Ms. Wilson, which I assume you want to pursue.
Yes, ma'am.
Your lawsuit suggests that your sister, in 1997, when she was arrested, used your name and identification. Tell me what happened.
She was arrested in 1998. I didn't find out about it until a year ago when I registered to vote. They said that I was a felon, that I couldn't vote. And she's got, that's me, Julia Pendleton, that's my maiden name, and this is my sister. And she was arrested for crack and possession of paraphernalia. And she had a broken jaw, so I hit her with a 2x4 or something. And so due to this, I couldn't vote at first. I had to carry around this from the Tampa Police Department saying that there's no warrant out for me, and I've never been arrested, and I've never been fingerprinted, and it was humiliating and degrading, and it's still, Julia Pendleton will always be her alias.
You have
always.
been arrested.
Never.
Well,
Yes,
she's
you
been
have.
arrested before. Ms. Carver, did you, in fact, use your sister's identity?
Yes, I did. In 1997, I did. And I spoke with her about it, and I confessed to her about it. And
When?
When I found out about it.
1998.
A year later?
Yes, and we did discuss this, and I told her, and I have felt very bad about this whole thing. I know it was wrong, and yes, I was on drugs, and I did a lot of crazy things. I have a nasty past. But she said that she understood why I did it. She said that she loved me, and she forgave me. And now all of a sudden, it's all back up. It's like, you know, my past is being thrown in my face. This is 3 years I've worked hard to change my life. And it's like it's constantly, every time she gets mad at me, she throws this up and shows me that nasty picture.
You sued
I'm
me.
sorry, but I just can't deal with it. And, you know, I want to get this over with because I have a nasty past, and I'm sorry.
Well,
But she forgave me, I
there's
thought.
3 warrants out for her from Florida right now. And there's a warrant out for her in Tampa. So that's 4 warrants from Florida, active warrants on for her arrest.
If they were active, I wouldn't be here right now.
I can give you the VOP numbers right here.
Like to see them?
And she said she'd take care of it. I've given her a year and a half to take care of it, and she hasn't made one phone call to get it taken care of.
What are the warrants for?
Violation of probation for grand theft and also possession of crack and bad check ring.
You know about these warrants?
Yes, yes, I do. And the grand theft was taken care of years ago. That one was from like 1992.
And the others?
The others were taken care of. The violation of probation was still active as far as I knew, but then my parole officer now said that there was nothing on the NCIC against me right now. Otherwise, they would not have allowed me to come here today.
No, they just wouldn't have extradited you because you're not worth it.
Ms. Carver, you don't mind if Officer Byrd gets in touch with your probation officer
Not at
to
all.
make sure that these warrants are still not outstanding, so I'm going to ask you to wait when court is over.
Yes, ma'am.
You give the probation officer, I'm sure he has the number, a call and ask if any of these warrants are still extant.
Sure thing, Judge.
Ms. Carver, my initial order was going to be in your favor for $1,200 for the rent that you paid. But the fact that you were arrested and used her identification without her permission, even though she forgave you,
Right,
she may have forgiven you until you filed a lawsuit against her.
right.
And now she said, well, now that you filed a lawsuit against me, I want to be compensated for the embarrassment, the humiliation that went along with this identity theft, which is
Right.
really what it was.
Yes, ma'am.
You had forgiven your sister.
Yes.
Okay. Until this lawsuit.
Yes, ma'am.
Okay. You're even. Who are you living with?
Myself.
Good luck. Check with Byrd. That's
Thank
all.
you.
Parties are excused. You may step out.
I think it's fair because I know what I did to her was wrong.
I don't hold it against her.
I've worked really hard for 3 years to straighten out my life, and I just wish it was not there to haunt me.
I hope she gets her life on track and does good.
We called your probation officer and everything is fine. Okay, so
Thank
you're free
you.
to go.
Thank
God
you
bless
very much.
Take
Thank
care.
you.
And now the next case.
All parties in the matter of Warren versus Quintel. Step forward, please.
26-year-old customer service rep Lakeisha Warren is suing her former friend, 28-year-old maintenance worker Andrew Quintel, and his mother Joan Quintel. Lakeisha says Andrew owes for unpaid loans and for kicking her car. Andrew has a countersuit for harassment.
Miss Warren, Mr. Quintel was your boyfriend for a while. According to your complaint, you made a series of loans to him.
Well, no, we weren't boyfriend and girlfriend, but I did make a series of loans to him.
He was a friend of yours?
Yes.
And in addition, at one point you say that out of anger and rage when you refused to loan him your car, he kicked it, causing some damage.
That's correct.
Why don't you have a seat?
Thank you.
All right, when was the first loan that you made to him?
12/27 of 99.
And how long had you known him before December of 1999?
About 4 years.
And tell me about how he approached you with regard to this money.
Well, his job is like temporary, seasonal, so he didn't have any money. And since I worked full time, then he asked me could he get a loan.
You have a cancel check?
Yes, I do.
Can I see it, please?
I actually have 3 of them and one more.
So you have 4 checks?
That's correct.
Okay. The first check that you have is $19.99 for $200, and you made this check payable to his mother.
Yes.
Why?
Because he didn't have a banking account to cash the check.
Then I see checks in the year 2000. So after he didn't pay you back the December loan, you gave him more money in February of 2000.
Yes.
Then there's another check here in April of 2001 for $1,500.
Yes.
Well, tell me about that one. That's made out to cash.
I went to the bank and cashed the check in the pretense that he would pay me back on his next work day, which was the 10th.
In April of 2001, did you take a $1,500 cash loan from the plaintiff?
No, ma'am.
You know anything about $1,500?
No, ma'am. That's new to me.
Well, let's get back to the $280. $280 that's owed for a couple of years now. She gave you this money. This is clear. These checks were written out to your mother. Were these loans for you?
Well, ma'am, me and Miss Warren, we were friends for a while, so I mean...
Could you answer my question?
Huh. Yeah, that wasn't a loan.
What was it?
I can't exactly remember. It's been more than a couple of times that she's given me money or I've given her money. It's been over 6-7 year friendship, so I mean...
Okay, let me hear about the car.
It was kicked on the right side and the passenger side. He tried to let the air out of the tires, too, because his friend had dropped him off.
Tell me about that incident in February of 2000.
I was at work. I was working 6:30 to 2:30. He came because he wanted to use the car to, I guess, to run some errands. I told him no. He tried to let the air out of the car. He kicked the car so hard the rubber fell off.
Now, after this incident, according to your paperwork, you gave him $1,500 in cash.
That's correct.
Why would you do that?
Stupid.
You have a counterclaim for harassment.
Yes, ma'am.
I want you to tell me what that's about.
Basically, I tried to end our friendship.
Why is that?
Oh, because I got a new girlfriend.
What do you mean a new girlfriend? I thought the plaintiff wasn't your girlfriend.
She wasn't
Why
my
not?
girlfriend.
So?
But
So you got a
she was
girlfriend?
a friend of mine. Yeah, I got a girlfriend.
And?
So the friendship started to deteriorate, meaning less and less time speaking and talking and being friends, and then nothing at all. And when this came about, there was numerous, phone calls and stuff to my mother's house when I was staying there at times, of hanging up in all hours of the night and during the day.
Well, why didn't he just leave me alone then? How can you stalk someone if they... Okay.
If you tried to stop it, why did you still continue to take money from her?
We were still friends, I
What's
would
his
try to
definition?
stop it.
I don't want...
Okay, go ahead.
I mean, we were friends, and it would stop for a while, and then it would go on again for a while.
He's confused.
I'm confused.
Well, basically,
Quite
ma'am,
frankly,
basically what
Basically,
it is
we
were
slept together, and that was it. That's it.
Shh, quiet.
Well, by her saying that, then you know why a lot of this stuff was going on then when I decided not to deal with her.
If you interrupt again, aside from the fact that you haven't proven your case, I'm going to throw you out. Do you understand?
Okay, go ahead.
Good. I have some advice for you and for your mother. Change your phone number and unlist it. And if she's being a nut, then you might just have to do that.
I would like to say I'm not calling those people. I
think that you, I should listen to me, Miss Warren. I believe that you're calling.
No, because someone's calling my house at all hours of the night, 3 o'clock in the morning,
I
hanging
think
up.
that probably, maybe his girlfriend is doing that. Are you telling me that you did not call more than 2 or 3 times a day, ever?
No.
Do you have any proof, Mr. Quintel or Mrs. Quintel, that the plaintiff called your home or place of business in the last 6 months? Because she says she has not. You have proof?
I have got.
No, she just has times and dates that she...
the times and dates that she has called.
No, I'm something from the phone company.
They don't have it.
So you don't have any proof?
No, it's my...
Okay. So far, Mr. Quintel, based upon the evidence that I've heard, you owe the plaintiff $30. That's all she can prove. The other checks have no indication as to what I'm speaking.
What about his harassment?
I've dealt with his harassment. I think, Miss Warren, that you have to get over it.
I am over it.
Good. Very good. Your case is dismissed with the exception of $30, which you have in fact proven. And with regard to your harassment, you have no proof of harassment.
Well, that's because they don't let incoming calls.
What do you want me to do about that, sir? Proof is what you need in court. And I suggest that if a relationship, a friendship, an intimacy is over, you move on with it, both of you. Yeah. And the problem is, if you did in fact take this money from her, and I'm not sure whether you did or whether you didn't, but that is, of course, a possibility, she would be doubly angry if you dumped her for somebody else. We understand each other?
Yes, ma'am.
Okay. So maybe if you did, in fact, take money from her that you did not return, and if you want this harassment to stop, maybe you should give her back the money. Do you understand?
Yes, ma'am.
And if you don't, she just may continue to make your life miserable. Do you understand that?
Yes, ma'am.
Goodbye and good luck.
हेलो दोस्तों, ये एक फूल है, इसमें हम कलर करेंगे। तो देखिएगा हम कलर कैसे करते हैं। वीडियो पसंद आए लाइक करें, शेयर करें, कमेंट करें। इसमें करते हैं हम ऑरेंज कलर। गाइस, हमारा कलर कंप्लीट हो गया है। आपको कैसा लग रहा हमें कमेंट करके ज़रूर बताएं।